Heidi, would you mind doing housekeeping? Thanks.
Welcome committee members, liaisons, and members of the public to the Legal Service Trust Fund Commission. Thank you for joining us. We will begin at 12. We are using Zoom with the goal of fostering a more inclusive environment and effective meeting. If you would like to comment during the meeting, please use the raised hand feature. To use the raised hand feature by phone, dial *9 on your phone's dial pad to raise your hand, and to do the same to lower your hand. Please utilize this tool to virtually indicate you would like to speak in order to help the chair facilitate this discussion. Going forward, all Legal Service Trust Fund Commission and committee meetings will be recorded and posted on the State Bar website. A friendly reminder that this is a video conference and to please be aware of your surroundings behind you. For those using Zoom on a computer, when on mute, holding down the space bar will temporarily unmute you. If you use your phone to dial in for this meeting, please be sure that your computer's microphone is on mute to avoid audio feedback issues. Joining audio via computer is highly recommended. If an individual loses audio, they can call in separately using the Zoom conference number. Thank you.
All right, let's call the meeting to order. Kim and I wanted to just recognize the fact that we are on video and being recorded. So please be aware of your surroundings, as was just noted. One of the people you will not see here today is Bob Planthold, who some of you know is no longer with us, passed away since our last meeting. And Bob was one of our client members. He will be recognized, I hope, by the legislature for his dedicated unpaid service to the community, and in particular to our community, in which he was a great contributor. In my 11 or 12 years of doing this work, I cannot remember any other client member achieving the status of committee chair than Bob. Certainly deserved that role on the bank grant committee, which Tammy has graciously agreed to chair. His passing, and I want just to set the record that we all appreciate tremendously. He gave us one anecdote that I will tell you about Bob as indicative of his commitment to his work was when I made presentations to the State Bar, Bob would watch them, and I had the habit of referring to the commission as both sword and shield to both protect the State Bar trustees whose involvement was less than its responsibility, and to advance the interest of the State Bar on behalf of the trustees. And Bob reminded me that sword and shield reminded him of the Soviet Union's flag. And since 1989, he wanted me to take that down and use other words to describe our function. He was totally committed to our work. He did it with a sense of humor and grace, and he'll be missed.
Okay, I'm going to talk a little bit about Bob outside of the commission, because I'm not sure how many people knew that he was often referred to as a giant in the disability rights community. He was also known as the Hammer. You did not leave a meeting or try to settle anything or negotiate a new policy related to disability rights unless you first spoke with the Hammer. If you Google Bob Planthold, you will come up with an incredible range of tributes, from disability rights advocates to Bay Legal Services, to even the transit authorities to whom he was frequently protesting. So he really was a giant. He was on both the, he was both an activist for the sunshine in government as well as disability rights, particularly in the area of transit, as his physical mobility impairments are a result of having polio, contracted polio at the age of 2. He was the only person in San Francisco to have served on both the city's Open Good Government Watchdog Commission, referred to as the Sunshine Ordinance Task Force, and the city's Ethics Commission. The only person. So we were really, really lucky to have him. One of the sweetest comments and most powerful comments I read when I was doing research on him was that he was a mayoral aide who said that he represented a kind of activism that made San Francisco a better city. That's a pretty profound statement for someone who did all of this work, as well as simultaneously being a father of 2 sons. If you read some of the obituaries, it talks about how he would get on the bus with his Canadian crutches, which apparently were bright yellow, so he really stood out. And he'd have his 2 little boys' backpacks, and he would be taking them to school and to soccer games. So we saw a slice of him, but I wanted to share with you his big role outside of being a commissioner. And so that was a marvelous commissioner that we had. We were really, really lucky to have him. He really was a very larger in life person. So those are my comments. I don't know if anybody else on the commission wants to share anything about him.
Thank you, Kim. I see Tammy's hand raised.
Great.
No? All right, so we'll, Corey and then Dwan.
Or you're on mute. We can't hear you.
There we go. Corey, we still are unable to pick up your audio. Dwan, while Corey's working on that, do you want to pick up?
Yeah, I wanted to say, Bob was truly very dedicated to the commission and this work. He and I have had many long late night calls about, various motions and the funding. And, just the week before he passed, Dan and I had a meeting with him, with Tammy, to do the orientation. And he was just very, very excited about being the chair of the bank grants committee. He had a lot of wonderful ideas of, what we could do with that remaining funding. And we're still in shock, because literally it was a few days before Dan and I met with him, and he just brought so much enthusiasm. So greatly missed. And I know we're having trouble promoting Chris Schreiber, but Chris reached out to the legislature, and they are going to be adjourning one of their meetings in tribute of Bob. And also they're putting together a nice certificate for him. So we will be sending it to his family as soon as we get it. So thank you so much, Chris, for doing that.
All right, Corey, it doesn't appear on my screen. So Dwan, do you want to proceed with roll call?
Okay, and we're still, can someone help promote Chris? Oh, I see him still in the attendee pool. Kim, can you get him promoted, or can someone help Kim promote him?
It's not giving me the option to promote him.
Chris, Elizabeth, can you help out?
Yeah, we aren't able to promote him, but we did unmute you. So Chris, if you should be able to speak without.
He has his hand raised.
Yeah, and I'm asking him to unmute.
Chris, I think the unmute has to come from your end.
And I think, Chris, if you press *6, that might unmute you on Zoom.
I think it's *9 according to the.
Oh,
he's unmuted. No, yeah.
He's unmuted. Chris, can you see
is.
it working?
Yeah.
Yep.
Okay, great. Okay, I'll do roll call then. Rhinus,
Here.
Savage,
Here.
Schreiber,
Here.
Vanarelli, Aglagi,
Here.
Al-Saraf, Ball,
Here.
Fightmaster, Bennett,
Here.
Blakemore,
Here.
Boschelli,
Here.
Connolly,
Here.
Friedman,
Here.
Balkin, Biskin,
Here.
By the way, thanks for the kind words about Bob. He will be missed. He was quite a character, real factor in our meetings, and I learned a lot from him. So I appreciate the words that were said today.
Judge Klein? Judge Klein, are you on?
I think he said he was coming late. Excuse me, Dwan. I think he said he would be joining
Okay.
us later.
Great, thank you. Cruz? Diana, are you there? Lee?
Here.
Okay, great. Mahoney?
Here.
Meeker?
Here.
Judge Yaskell?
I'm here.
Judge Seligman?
Here.
So we have quorum. I'll do our liaisons and staff. Selena Copeland?
Present.
Bonnie Huff?
Here.
Melody, I think you're attending on her behalf?
Bonnie's here.
Oh, Bonnie is here. Okay, great.
And Melanie is here as well.
Melanie, okay, great. You're both able to attend. Great. Elizabeth, Heidi? I saw Heidi.
Here.
Crystal, are you here? Danielle? Okay.
Here, and it looks like Crystal is in the attendee pool.
Okay, I saw Danielle, I saw Chris. Erica?
Here.
Dan?
Here.
Donna? Brady?
Here.
I'll turn it back over to you, Rich and Kim.
Are there any members of the public who would like to announce their presence, either in person, on the Zoom or on phone? Hearing no responses. Let's proceed with the agenda.
We're on agenda 2, call for public comment.
Since there are no members of the public who've identified themselves, maybe we can move to the third item.
Okay, the single item on the consent calendar is for approval of the meeting summary and action items for the December 13th, 2021 meeting. I hope you've had a chance to review the summary. It's quite lengthy. And are there any comments, additions, corrections? Yes, Jim.
Yeah, I have a comment on page 7 where they're talking about the homeless prevention grant subcommittee in terms of how we scored the grants. And
Okay.
this is an issue that we'll discuss probably a little bit later when we talk about the homeless prevention grants later in the agenda. But I really didn't like the two terms staff-led versus commission-led approaches to doing these discretionary grants. I mean, it's really a difference between a scoring team made up of a commission member and staff versus the subcommittee as a whole. And I don't like the term led because it sounds like control is being turned over to staff or control is being completely run by the commission. And it's in light of, I know, Kim, you were involved in the discussion, the same with you, Rich, about the issue of the Appendix I review and the whole idea of whether or not the commission should be disbanded or replaced by an 8-member commission, and the issue of having staff take over total control of discretionary grants. So I just didn't like the terminology.
We can get that corrected if you would like us to replace it with a scoring team. Is that, I believe I heard you say.
Scoring team, that would be fine.
We can make that correction.
Any other corrections?
If not, Jim, do you want to make the motion for approval with that editing of the language?
Sure, so moved.
Okay. Do we have a second?
I'll second it.
Okay, I'll do roll call. Rhinus,
Aye.
Savage,
Yes.
Schreiber,
Yes.
Vanarelli, Agagi,
Yes.
Al-Saraf, Ball,
Yes.
Fight Master, Bennett,
Yes.
Blakemore,
Yes.
Bushelli,
Yes.
Connolly,
Yes.
Friedman,
Yes.
Galkin,
Yes.
Iskin,
Yes.
Judge Klein, Cruz, Lee,
Yes.
Mahoney,
Yes.
Meeker,
Yes.
motion passes.
Thank you. Do we know if Pablo Ramirez is ready?
Yes, he is. Kim, would you mind promoting him from the
Okay.
attendee pool?
So just by way of introduction, I think that we discussed at a previous meeting our idea to have two of the grantee recipients make very brief presentations so you can understand the work they do, ask any questions of them. We thought we were going to have two, but there was a problem with the co-deputy director for East Bay Community Law Center. But we are delighted to have Pablo Ramirez, who's the executive director of Legal Aid Society of San Bernardino, who that's a program we have worked with a lot. So Pablo has, unfortunately, only 5 to 10 minutes. I'm sure he could go on for a while, but we'll get an overview from him on their program's work.
Okay, may I share a PowerPoint?
Of course, Pablo.
I'll be quick. So good afternoon, Commission, public, and State Bar members. I appreciate and thank you for allowing me an opportunity to speak. As mentioned, my name is Pablo Ramirez. I am the Executive Director for Legal Aid Society of San Bernardino. You should be able to see a PowerPoint. Can I confirm?
We see it, Pablo.
Perfect. So
Yeah.
I am just kind of highlighting the technology component that Legal Aid Society of San Bernardino wants to focus on serving a rural area and a low-income and senior community. So we serve San Bernardino and Riverside County, which is considered a rural community. Something about myself, I am the executive director since September of 2020. I have two passions. One of them is helping people, whether it's in my personal life, going out as a Lions Club member and giving back to the community. And the second one is technology. So my goal is to kind of combine both of my passions of helping people and technology to kind of serve the rural population and the low income and senior population. First and foremost, as you alluded to or mentioned, we did have some challenges back in 2019. I took over in 2020, and my first goal was to ensure that we were providing high quality services while we were being compliant and ensure that we continue to serve the low income population. The commission kind of helped support this mission by giving us an opportunity to address these challenges during a turbulent moment and continue to support us with guidance, support, and which allowed us to provide continued uninterrupted services to the low income community. So because of the commission, we continue to serve the population. Our second challenge was kind of addressing the pandemic challenges that most, if not all, of the world experienced. We had technology challenges, administrative challenges, some process improvement, and some intake challenges. The way we addressed these challenges, first and foremost, we upgraded our legal system, our case management system to Legal Server, which allowed me to customize our fields, develop guided navigations, would nudge our staff members to make the right decision, advanced funding filters, which prevented them from making the wrong decision, and allowed me to do virtual audits. We also had some challenges with our morale and our team building because of the remote work. So I transitioned to Microsoft 365, allowing us to leverage Microsoft Teams, virtual trainings and videos, and do some step-by-step tutorials. It also helped us allow us to do more staff meetings and litigation meetings and collaborate on remote projects. I also, in order to improve our knowledge, registered or joined the Practicing Law Institute, which allowed us to expand our staff members' knowledge and included it in our onboarding and continuing learning agenda. I also took some administrative challenges, improved our policies, developed process improvements, which allowed us to address client needs in a linear fashion rather than a zigzag fashion, and improved our fiscal controls by transitioning to the online QuickBooks, which allowed us to be more transparent, Bill.com, which allowed us to pay accounting and our invoices in a quick fashion while maintaining compliance, and Divvy, which allowed us to use credit cards in a similar fashion. We also had the challenge of reaching our community members and how our clients were reaching us. Initially, we had unified telephonic intake. We found that this kind of created a bottleneck for our tech savvy clients and our non-tech savvy clients. So in order to address that challenge, I created an online intake system that allowed our tech savvy clients to apply online, our QR application process, which allowed our clinics to apply online and no longer required paper applications, and an SMS text intake feature, which allowed our rural clients to apply while not having a broadband or any kind of challenge or internet. All of these changes allowed our telephonic intake to be focused and hopefully allow our non-tech savvy clients or clients who do not have technology to get through in a faster fashion, and also alleviated our staff's challenges and allowed us to serve the same population or larger population with the same resources. Lastly, because of the collaboration with the state bar, the commission, we were able to expand. We had a state bar legal design lab where we expanded our population through the text messaging, which was made possible through the HP2 funding. That included a lawyer component, which allowed us to quickly fill out legal documents by the client completing a survey. And again, that's possible through the HP2 funding. We expanded our Caregivers Access to Justice project, which serves 41% of the self-help litigants who file guardianship and conservatorship, to include domestic violence assistance as part of the HP3 funding. That project is kind of important because it allows us to provide wraparound service to our domestic violence victims, and it provides our domestic violence victims who want to flee a volatile situation with one of our local partners who provides housing, life skills, work improvement, and daycare, as well as education for their children, which allow them to be more independent. Because of the Partnership 2.0 grant, we're able to expand to the Riverside Superior Court and allows us to increase our assistance to domestic violence victims. Because of the American Bar Endowment Grant, we're able to develop interactive videos, which are going to help our low-income population facing eviction quickly prepare and hopefully be better equipped to handle these matters. And lastly, one of our partnerships with, because of the California Infrastructure Grant, we are collaborating with Legal Aid Foundation of LA, Neighborhood Legal Services of LA, mental health advocates to develop an outcome gathering method, which is going to allow us to quickly address and find out where we need to focus our resources to better provide services, kind of emulating the Cleveland, Ohio grant that they had. We also have State Bar and other funding. Our IOTA NEF is our strong foundational, which allows us to include our pro bono volunteers and expand our program. Our Partnership 1.0, as mentioned, helps us help our caregivers who are trying to care for their elder adults or their minor children who need supervision, which allowed us to serve 41% of the guardianship and conservatorship population. We do have our rental program, which we try to combine with legal services in order to ensure that the client has the legal support and the long-term financial support to remain housed, as well as our city grants and our other funding, which allows us to continue to serve the low-income areas. This is made possible through the Commission's continued support. And I will quickly touch on our lack of our rural challenges that we currently face, which are, as I mentioned, lack of broadband or other digital tools, distance challenges, lack of awareness of services, pro bono challenges, and inability to afford technology. Now, because we continue to get the support, we can quickly address these challenges by expanding our outreach efforts, by teaming up with community centers in rural areas. That includes Victorville, Joshua Tree, Rialto, and other courts, as well as continuing to work with local universities and other legal aids to develop a program that includes Cal State San Bernardino, along with legal aid going out to the poorest areas where we can offer legal clinics and digital assistance. That is still pending. We also have our technology variations where we were able to develop that SMS text. We include some hybrid appointments that allows us to help telephonically, virtually, and in person. And we continue to search for other methods. I will point to this quick research. According to this Pew Research, 24% of the households under $30,000 don't own a smartphone. 43% or 4 in 10 adults with lower incomes do not have home broadband services. 41% do not have desktop or laptop computer. I point this out because it's important that we continue to highlight to bridge that gap, digital divide, by going out and reaching our community where they are located. We expanded our pro bono volunteer program through marketing efforts, which includes ED sign up, volunteer options, which include flexibility, hybrid, telephonic, or on-site volunteers, recognition on our website and our fundraiser, and also providing MCLE videos, which is made possible by LRAP. And the commission has continued to support us to expand our volunteer opportunities to the Riverside Superior Court. This QR code here is an example of how quickly our volunteers can sign up. They simply scan it and they can register to become one of our volunteers. I believe this is our last slide, so I appreciate you guys being in there. So because of the commission, we actually continue to serve, and who we actually serve. The San Bernardino County's rate of poverty is higher than the state and national average, which is 16% of the population, or 334,000 people, live below the poverty line. Riverside County is 13.7%, or 325,000 people live below the poverty line, which both of them are higher than the national average. And because of the commission, we were able to serve 4,087 people in 2021 with matters that include housing, family, probate, consumer employment, public benefits, and other matters. So with that, I appreciate the commission's continued support during our turbulent times, and I appreciate you guys giving us the necessary funding that we need to continue to serve a much needed population. And I am happy to pause for any questions.
So this is Rich, Pablo. That was a great presentation. Really appreciate it and compliment you on the work that you're doing. When we made our audit, and we'll go into this later, of your service provider, we were fortunate enough to meet members of your board. Can you address what your relationship is now with your board members, how they interact with you and what kind of support you're getting from them? And secondly, can you also address the issue of how you track your pro bono hours?
Yes. All right. So our board of directors is very involved. I can say for a fact that I probably talk to at least the board president almost daily whenever we experience any challenges or just to give feedback. I'm very engaged. They are very involved in our board meetings. We always have quorum for the most part. We've never had challenges where the board does not show up to meetings. We have monthly board meetings. I anticipate that continuing. So we have a very strong board support, and we were able to successfully complete our strategic plan because of the support. So I believe we have a strong board that we communicate constantly, and they're either calling me or I'm calling them to bounce ideas and any challenges that we may experience. As far as our pro bono hours, we've developed a stringent requirement that twofold. One of them, we have a pro bono coordinator that kind of reaches out to each and every one of our pro bonos. We have redundant processes in place where they receive emails and they reply and just confirming that they volunteered. All of our pro bono hours are placed into our case management system and tracked with documentation to support each and every one of their work. which may include emails where they acknowledge and they provide us their feedback and the kind of work and how many hours they actually focus on the client. And then I have constant audit to make sure that we are accurately reflecting all our pro bono hours.
Thank you. Pam has had her hand up.
Hi, I just wanted to say thank you for an excellent presentation. Very well done. And my question was in regards to the SMS texting. How are you able to preserve that data for your clients?
So that information actually, when they text it, we built it with our legal server module. It comes into our legal server, it kind of goes in limbo. One of our staff members will review the data, verify its accuracy, and then transition it into our legal server database.
Okay, thank you.
You're welcome.
Eric?
Yeah, Pablo, a great presentation. Thank you. Just two questions, maybe for you or anyone else. What is the Stanford Law Design Lab, number one? And secondly, what program did you use to do your slides? Because they're pretty slick.
I just kind of went in there and I developed some, and then I believe I got some templates for 24 hours. 24 slides. And I think Selena's probably the best person to talk about the Stanford Design Lab since that's her alma mater.
You may know more than I do now at this point, Pablo, but the Stanford Design Lab is really a partnership between the Stanford D School. So that's the School of Design at Stanford and Stanford Law School. Margaret Hagan runs that project. She has a number of students who work with her. And over the last several years, they've taken on major projects for legal aid organizations with a user-centered design. So it's not just like, how do things look, but how do people interact with the technology, or even, I remember projects she's had with Bonnie has been around signage as well. So their goal is to look at how we can use design, thinking through how the users will interact with that. They've also done several projects with LAC too, but it's a great program.
Exactly, and we were able to work with them closely, and in order to try to get these projects. I kind of got the idea from one of a state bar's meeting where they kind of had a roundtable in different organizations and how they're using the technology to serve a much needed population.
Pablo, we have time for just one more question, and Will's hand has been up. So Will, you can finish it off with the question.
Thank you very much. Thank you for the presentation. And I was wondering if you could talk a little bit about that urban and rural challenge. I spent some time, thanks to family, out in Needles, California. And what strikes me is even there, they're having a bit of a housing crunch and a lack of resources, from attorneys. It's a town of 5,000 right on the border. And how, at least at a systemic level, you think we can help address that lack of awareness and being able to reach out to a resource like your organization?
So with Needles, and especially also Trona, which we actually had they had a huge earthquake. We went out there and supported them. But with Needles, obviously our resources are very spread thin. So the reason we developed these different technology is try to reach them. My first goal is to try to go out to Needles, but obviously that's like a 4-hour drive from where we're at, if not, might be longer. But I think continuing to do technology improvements and reach out to the community centers out there to try to do virtual consultations on their site, which is what I'm going to try to hopefully expand to, and hopefully get some local partners and volunteers out there that can actually meet with clients on site. That's one of my goals, is to continue to expand the collaborations with the community centers. While I'm not there yet, I hope to be there soon, because I do understand that while a smaller population is out in Needles, there's still a great need, similar to Trona and other areas out that way. So I hope to get there one day. I'm not there yet, but I will continue to use technology and our volunteers to reach that population.
That's excellent. And this sounds like great use of technology, especially for people who might want to help out someone else and understands the technology. So thank you so much.
Thank you.
Pablo, thank you. I'm sorry we don't have more time. We have a packed agenda, and we appreciate your coming and presenting the PowerPoint, taking the time to put that together. It's very inspiring and very creative use of technology to further access to justice. Thank you so much.
And thank you all for allowing me to speak, and have a wonderful meeting.
Thank you. As you can tell, Rich and I are sharing. We're co-sharing as we're co-chairing. So we need to jump to item 7, which is HP, because of people having other commitments. Schreiber has to leave early, and then Amin is leaving early also.
Great, thank you. This is Chris McConkey, Program Supervisor with Office of Access Inclusion, and I'm going to be co-presenting with Dwan and Jim at times. My understanding is we have just about 20 minutes on the agenda, so I'm going to try and leave a little bit of time for some discussion of the resolutions at the end and not take up too much time with staff's presentation. So I'm going to go ahead and begin the slow process of sharing my screen in one moment. Exit presenter view and share. Okay, sorry about that. So hopefully you should be seeing the slide now. So there's 2 items on the agenda. The first one is hopefully pretty quick. The HP Funds Committee met on January 28th to review a single request to revise a homelessness prevention grant budget that rose to the threshold of committee and then today commission review. So this is with respect to a single budget revision request. So this is a homelessness, and this was in the materials that were posted for today's meeting. So that's why it says please see the materials, but I will do like a 30-second explainer of this request. This is a homelessness prevention 2 formula grant. So the homelessness prevention 2 grants and the homelessness prevention 3 grants do overlap for several years. So this is number 2, it's formula. And this request is from Inland Empire Latino Lawyers Association. For the newer commissioners, if you were curious, typically for the Legal Services Trust Fund Commission administered grants, programs can sort of self-approve their own budget revisions, usually up to and inclusive of 10% of their total award, deviations of 10% or less. There were 10 requests for the HP2 grants. They were self-approving. The Office of Access and Inclusion staff typically has authority to review and approve revision requests where the sum of the departures or deviations are between 10% and 25% of the total award. There were 5 of those requests. Staff looked really carefully at those and found them to be reasonable and approved them. And then there was this one request that was at or above 25% of the award. So Ayala's request was 44.5%. The deviation was 44.5% of their 3-year grant. They have a smaller HP2 formula grant. So their whole 3-year grant is only $75,933. The total deviation was $33,821. So it's about 11, if you average it out, it's about $11,000 per year, a little more than that. It's actually not a huge departure each year, but it does still come out to be almost half of their award. And then my promised 20 to 30 second explainer, in case you didn't have a chance to, if you can't remember from the materials, essentially their deliverables are going to stay the same, but they shifted their model. Ayala shifted their homelessness prevention to project model to be one where an in-house staff attorney would deliver the homelessness prevention legal services to one that's actually more aligned with their normal delivery mechanism of recruiting pro bono attorneys and students to deliver legal aid. They were actually going to use this grant to sort of try a more in-house delivered model, and then they realized it was going to jeopardize their private attorney involvement funding through the Legal Services Corporation and also their pro bono allocation through the Legal Services Trust Fund Commission, and that what they do best is, or one of the things they do very, very well is recruit, train and supervise pro bono volunteers. And so they actually are shifting this project back to that. And that means they're moving spending from in-house attorney salaries to the other staff row of their budget, which will be a non-attorney pro bono coordinator. Deliverables will stay the same. Non-personnel rows are about the same and admin's about the same. So staff recommended to the Homelessness Prevention Funds Committee that they recommend approving it, and then the committee met on January 28th and recommends to the full commission that it approve this revision request. And I see Rich's hand is up.
Just a quick question, Chris, for the benefit of all of us. The funds that are now freed up by this revision, what happens to them?
Oh, great question. I'm so glad. This is important to clarify. They're going to keep their whole award, so they're not giving anything back. What this revision is the 44.5% deviation is if you look at the amount of money they're moving from the attorney row of their budget to the quote other staff row for the non-attorney pro bono coordinator. That is about roughly about 44% of their award. That's the bulk of what changed, but they're keeping the money. They're just spending it on a different kind of professional. So instead of it being an in-house staff attorney, they're going to be spending on a non-attorney pro bono coordinator, but they're not going to give any money back. So they're keeping their full award. If that was unclear, I can try and describe that in a different way because I know we have some new commissioners too. So.
Right, it was quite clear for me. Thank you.
So this was the one that was the particularly quick agenda item, and we'll need the rest of the time for everything else. But I see Jeff's hand is up. Jeffrey.
Yes, thanks. Chris, I thought I read and I thought you heard, I just want to confirm deliverables are the same. So the fact that they're making this change from a staffing standpoint has no impact on their ability to produce results from our investment.
That's correct. Yeah. Thank you for asking that. And Eric.
Yeah, just real quick, wouldn't the deliverables increase actually if they're moving from just kind of one attorney in-house to kind of leveraging a lot of outside attorneys?
They might, and I think the deliverables and the way that they describe them in the application, and it's actually, I went back and looked at their budget revision request really recently, but it's been a while since I looked at their application, is it's a number of clients served. And so they're saying they'll still be able to reach at least the same number of households, if not more. But they don't anticipate this shift from an in-house staff attorney delivered legal aid model to a pro bono attorney coordinated model to decrease the number of services. And so Eric, they might go up. Hopefully, that would actually be a positive development from this revision request if that happened. Yeah. So we're doing fine on time. I don't mean to actually rush this one through. It's just that this was the quick one, but if there are any other questions, I'll also tab back. I don't know if they're really long. The full explanation is in the posted materials. It didn't fit on the slide, but if anyone has any more questions about the substance of it.
Now, Chris, if you could go ahead and move up to the next slide, I'd like to make a motion to approve as you had it presented right there. Thank you.
I'm glad to second that.
I'll do roll call. Rhinus,
Yes.
Savage,
Yes.
Schreiber,
Yes.
Vanarelli, Aglagi,
Yes.
Al-Saraf, Ball,
Yes.
Fightmaster, Bennett,
Yes.
Blakemore,
Yes.
Bushelli,
Yes.
Connolly. Connolly, Eric, are you still there?
Sorry, I couldn't get my unmute off.
Oh, okay.
Yes.
Thank you.
Sorry about that. Yes, I'm sorry.
Friedman, no problem. Friedman,
Yes.
Galkin,
Yes.
Iskin,
Yes.
Judge Klein, Cruz, Lee,
Yes.
Mahoney,
Yes.
Meeker,
Yes.
motion passes.
Awesome. Sorry, it took me a second to get to the unmute button. Okay, so I can also slow down a little bit because this next one is the one that I think our Homelessness Prevention Funds Committee Chair, Jim, wants to save time for discussion for at the end. I think the chair has a question.
Chris, just a time check because we only have 15 minutes and Chris Schreiber needs to hop off and he's on HP. Can you shrink the presentation to about 5 minutes so that we have time for discussion?
That's what I'll do. Yeah. So apologies if there's something that goes by really fast, but this is also in the posted materials. So the HP Funds Committee also discussed on January 28th updates, refinements rather, to the homelessness prevention grant reporting schema. So again, I mentioned there's 2 grants. the Homelessness Prevention 2 grants, and the Homelessness Prevention 3 grants. So I will, given the time constraints, I'm going to actually probably skip a few bullet points as I go along and just touch on what I think is most important. But the most important thing from this slide is just to remember that the HP2 grants have, these two grants overlap. They're both 3-year awards for the most part. HP2 is 2021 through 2023. HP3 is roughly 2022 through 2024. The most important thing to remember is HP2 derives from state funding. And although the HP3 grants came to the commission through the State Budget Act, it actually derives from federal funding. So they do have different reporting requirements. That's the most important thing from these two slides. So HP2 is just an annual reports and a final report, and HP3 has the federal government requires quarterly reports as well as what they call interim reports, which are basically annual reports. So this would save us a lot of time by just running through this. If you're curious, the particular federal funding is state fiscal, coronavirus state fiscal recovery funds. So I would have gone through that in a little bit more detail, but this is the one that these next few slides are really important. So the need to update the HP3 reporting, as some of the commissioners may remember, the legislature told the Judicial Council and the Commission through the State Budget Act that it wanted the Commission to administer the HP3 funds as soon as practicable. For the most part, most of the HP3 funds as soon as practicable. The Commission took that to heart, launched the application in August. The State Budget Act was passed in July, launched the formula application in August, launched the competitive application in September, and at that time, the Department of Finance still had yet to communicate what the federal reporting requirements are going to be. So we had to use, I guess for lack of a better term, like placeholder requirements. We had to communicate sort of like interim reporting requirements that were based on the existing ones for the HP2 grants. Later, the Department of Finance clarified what the federal reporting requirements actually are and what the due dates are. And so the committee needed to meet to update them. And that's what's coming to you today. So that's the essence of this slide. So in the posted materials, there were some tables that actually detail any and all changes. So this slide sort of summarizes the major ones. So I will actually touch on each of these bullet points. All of the changes would promote compliance with Department of Finance, so that's DOF here, / US Treasury, because ultimately Treasury at the United States Department of Treasury at the end of the day is the one that's issuing this guidance. Requirements for the HP3 funds. So those are the federally sourced funds. It would also make the data set much more complete and precise for HP2, which is state funding. And we want the two reporting requirements to be as consistent as possible because these grants overlap. So the major changes that would really affect just HP3 is it would align the quarterly and annual reporting topics to what the Department of Finance and US Treasury later clarified is required. Major caveat there, the Department of Finance and US Treasury continue to say that they may update the guidance as they go along. So, but this recommendation reflects the current guidance. It would also, for HP3, add the requirement that programs report their spending on full scope services in eviction cases when they're already going to be reporting their quarterly spending. So it's like an additional question. That's because the federal government is requiring data on spending towards what it calls evidence-driven interventions. And so this is the one sort of like evidence-driven intervention that we had identified in the project plan for US Treasury. Major changes that would apply to both HP2 and HP3 by making the data sets much more complete and precise is the reporting requirements would require a main benefit code. And for the newer commissioners, the main benefit code is roughly synonymous with like an outcome code, but we call it main benefits codes, the ultimate good that the client experienced as a result of the services. It would require one for cases, and it would ask the program to note if it can verify that the outcome was achieved. And this is important for satisfying the HP3 or the federal reporting expectations for HP3. The alternative, the reason we needed to change this is currently if they don't select a main benefits code, because it's not strictly required, you lose information on what the crux of the service was, and it's hard to verify if it was even qualifying homelessness prevention work. So this is necessary to be able to prove or demonstrate on the face of the reports that it was qualifying work. It would remove main benefits that have missing or unclear connections to homelessness prevention. Those main benefits would otherwise, those extraneous main benefits would otherwise suggest unqualifying work if they had picked it. It would remove the existing, quote, other legal resolution, and where the level of legal service is unclear. There exists in the typical reporting framework for EAF funding and other code that some programs sometimes pick, but the existing codes, which run from counsel and advice as the lowest level of service all the way up to full scope representation and like a court decision, that spectrum of codes really captures almost the whole universe of legal, of depths of legal service. And so it removed the other, and it would tell the programs to pick the best one of the remaining codes, which are more specific. And then the last thing is when programs are providing data about self-help clinics, know your rights trainings, outreach events, and hotline calls, the existing reporting framework asks them to note the area of law, and it gives them options. It would remove all areas of law that weren't relevant to homeless prevention work, because again, similar to removing extraneous outcome codes, main benefit codes, picking one of those areas of law would suggest unqualifying work. So that's the summary of major changes, and that does complete the staff report. I am going to turn it over to our committee chair, Jim. And Jim, while I turn it over to you, I'm going to pull up both of the resolutions that the committee passed, and I'm going to have them displayed in split screen so you can introduce them and talk about them. And I note at the top which one passed first, which one passed second. And I'll turn it over to you while I make that change.
Okay, Chris, thanks for a great summary. Thanks for keeping it short and sweet. Just to place this in context, as he brings up on the proposals on the screen, I had the privilege of being the advisor to the working group during the Appendix I review, and where we faced, in my opinion, a consultant who was very hostile to the commission, at one point recommending that the commission be abolished, especially in its role of issuing discretionary grants, and it would be completely turned over to staff, eliminating the role of the commission as acting as, in Rich's term, a shield and a sword. Another proposal that came out from this consultant was that we have the commission be reduced in size to only 8 members, based on a faulty reliance on some organizational literature, which I looked into and objected to during the Appendix I review. And fortunately, those suggestions were not enacted. But because the minutes reflect what we do, I've been very sensitive to make sure that in the minutes of the Homeless Committee that we be very careful to distinguish between what is being delegated to staff versus what is being done by the commission subcommittee. And that because we had the short time period, we had to adopt a new approach to granting these discretionary grants instead of subcommittees of the subcommittee getting together where the commission members score all the grants. We had to rely on a scoring team. And it's true, we had complete commission or subcommittee commission involvement in the calibration meeting, in which we calibrated the different elements of the scoring rubric. And the scoring team graded all of the grants, involved a scoring team involving 3 staff members and myself. And then we presented to the subcommittee as a whole the grants that the scoring team thought that there was some possibility of lack of agreement or some possibility where commissioners would want to have to weigh in on it. And this was an unusual approach given how we've handled discretionary grants in the past, and that's why I was sensitive to this over delegation issues. Now, we had 2 resolutions. Let's see. The further resolved, the commission delegates to staff bar staff authority to update HP3 reporting topics and deadlines when necessary to comply with the state and federal requirements. That's the first one we discussed. I wanted to modify that to the second one that's underlined in the yellow, adding major substantive changes will be made in consultation with the Homeless Prevention Funds Committee Chair, so that any outside observer reading the minutes would see that the commission would be involved in any major substantive changes. Now, I've had discussions with Juan and Christopher. They know I'm not interested in micromanaging. I consider something, I've told them what I consider something major substantive, such as, let's say the finance committee is not interested in rural issues, and they decide they don't need to report on that, whereas state bar is interested in rural issues, and we wouldn't want to eliminate that. Some of the biggest problems in terms of reporting dates and times of deliverables, that I do not see myself involved with at all. And as a matter of fact, I have been routinely attending Dwan's, I think for lack of a better term, Krista, we call those evaluation meetings weekly.
Yeah, like reporting meetings with the Judicial
Right.
Council. Yeah.
And I don't interfere or micromanage on those. I've only made certain substantive suggestions, like when we were discussing how do we report rural issues. And I made the suggestion that we clump counties as in the same classification groups that the Access to Justice Commission did in their rural access report. And also technical issues like how do you handle blank cells on outcomes? Is it a true blank, that is, it is a zero? Or is it something that's not applicable? Or is it truly missing value? So it's just technical issues like that. Now, in fairness to the rest of the commission, not all of you were involved in the Appendix I review, although several commissioners that are not on the committee were involved, that are attending today. Also, in terms of raising this issue, some of my committee members who were on the Appendix I review were not as sensitive to this issue of overdelegation. Some were. And so there was a difference of opinion on that. And so hence we had the two different resolutions that were both voted on and passed. And I think the reason why the first one was passed is it was my problem in terms of not being a very good parliamentarian, because I did raise a concern about having a change in there, but we did end up voting on the first one first and then the second one second, as opposed to holding off and just voting on the second one.
Yeah,
So-
can I also clarify something real quick? It occurs to me now that I'm seeing it on the screen. With the version of this that the committee passed, they passed both of these. The only change was when the committee passes it, it says things like the Legal Services Trust Fund Commission, Homelessness Prevention Funds Committee recommends approving blah. So I fixed that so that it looks like how it will look when the commission passes it. So it's going to say commission approves, but essentially it's the same language. I just wanted to clarify that in case anyone was wondering. The committee does not pass a resolution that says approves. It says recommends approving, blah, blah, blah. Okay.
So I can't see raised hands, Chris. So if you could handle that.
Yeah, so no one's, yeah, Catherine has her hand raised.
Thanks so much. And thanks, thanks, Jim, having lived through the Appendix I review, something I hope never to do in my life again. I guess my only question is, so the second proposal is fine with BAR staff in addition to the recommendation of the committee, right? There's not a disagreement between what staff wants and what the committee wants. Is that fair, or is there in fact?
That's, if I may, Catherine. So the staff recommendation was the first motion. And we're proposing this, we believe that first motion is really narrow. We would only make changes to the reporting requirements if there was additional guidance from DOF or the Treasury to make those. So we really wanted a narrow motion so that we could move quickly, because we often get updated guidance from DOF, Treasury, so that we would have the authority to move quickly. We are concerned about the second motion, and not because Jim hasn't been great as a committee chair and we love his feedback, but more of the precedent setting that it would cause and the expectation that it would have for other kind of committee chairs to be as involved as he has.
Kim Savage has her hand raised.
I just want to add to what's been said so far, which is there was concern raised about the language in the second motion, which is major substantive changes, that some of us feel that is a phrase that is a bit ambiguous, and which makes the second proposal a little more difficult to basically implement.
Okay. And I see Brady has his hand raised.
Yeah, I was just going to share, and I'm sort of new to this issue, but on first look and listening to Jim's thoughtful comments, at least with the example he gave, I see the first proposal is pretty narrow that, you know, the delegated authority is only when the changes are necessary, in other words, required to comply with those requirements. And the example he gave seemed, at least as I heard it, was, well, if the state and federal aren't going to require rural reporting, well, we don't want to decide to get rid of rural reporting you know, that would be a major change, and we want to bring it back to the committee chair at least. But I wouldn't actually read that as covered under the First Amendment, because I doubt, I mean, unless the state did say, no, you cannot require this reporting. I mean, the first proposal is about, you know, the changes we need to make to do the reporting we need to do. I don't think that federal or state authorities are going to tell us to stop doing the reporting, that additional reporting that we want to do. So I'm having a hard time seeing why that change is necessary, given that this is limited to actually what we're required to do to meet the federal and state requirements.
I will just add that it was staff's intent when they had originally proposed this one before January 28th, that staff would only make the change if the Department of Finance the State Department of Finance communicated that something was like non-negotiably required. We would just make the update.
Right.
And then Bonachet has her hand up.
Thank you. So I'm a member of this subcommittee and wasn't able to attend the day that this issue came forward, and would have voted in the camp of going with the first proposal rather than the second proposal for sure. And here are some of the thoughts that I have. The first thought is, with the new legislation in place, I don't believe that the commission, the Legal Services Trust Fund Commission, is in the position that we were in 4 years ago when Appendix I came forward. And as Jim said, there are many people here who are on the call, Corey, Christian, Rich, Judge Seligman, who were part of the Appendix I working group, and then myself and Kim were on the commission at the time. So we are aware of the events. This language, to me, I really want to know where it stops. So Jim is currently the chair of HP. We have HP grants going for an additional 2 years. Potentially, he's no longer chair next year. We have someone else in that seat. And God willing, we have additional funds coming from the governor's office for additional HP grants. So we don't have you, Jim, with the style, the astuteness, the way in which you've been working with the staff going forward potentially. And then the next question that I have is, so are we going to add this kind of languaging, which sounds like we need to, because we're setting precedents for all of the other committees and the chairs in those committees? And then at what point, and this is the part that I'm really having the most difficulty with, at what point are we just merely oversight, like a board's activity? And at what point do we become staff and boss to these, or supervisors to these very capable staff members who have their own supervisors? So this additional language to me seems really, I'm just going to say, disrespectful to the staff and the work that they're doing. It sounds like we don't trust and we haven't moved beyond the 4 years from Appendix I, and we need to at some point. And it feels like it's overreaching. Thank you.
I think Rich had his hand up next.
Yeah, I don't know if Jim wanted to answer those questions that were excellent questions from Bonachet first. But to me, this is a jurisdictional issue. Statutory jurisdiction of the obligations under SB 211 grant to the commission the role that it presently plays. And the question is whether or not within that jurisdictional grant to us, whether we have the power and authority to delegate to staff. And that to me is a question that Brady might be able to help us answer. In addition to that, this isn't suggesting either one of these, that there would be no oversight by the commission. It seems to me that oversight is an obligation that continues. We have an obligation to the state, and we have an obligation to the grant, the ultimate source of these funds, to continue our supervisorial role. Jim, as I remember it, and Jim, correct me if I'm wrong, was concerned that there might be the appearance in the first that the commission had somehow abrogated its responsibilities. And I want to make everyone sensitive to that concern. As a practical matter, what I heard Dwan saying, and I think Bonafshe echoes this, and that is that the staff does a very thorough and complete job. And this somehow might be interpreted likewise to not support the staff in the way we all do support the staff. And secondly, two other issues. One is a practical one. Would this second resolution slow down the working process, usually very heated? And this year is a very good example of that. That requires a swift movement by staff in order to meet its responsibilities. And secondly, does the language create an ambiguity that would lead to more problems than it solves?
So since the last two commissioners ago have both invited Jim to respond, I think we should go to Jim, but I want to just note that then I have Will, Catherine, and Corey. But Jim, did you want to respond, or did you want to let Will, Catherine, and Corey go next?
Yeah, just a quick one. Yes, Rich, I agree. That's what I was trying to say, and that was the rationale for my earlier comments on the minutes where we said staff-led scoring team. It was really a scoring team and collaborative effort. I don't see that was being led by me nor being led by staff. We were all colleagues together. As a matter of fact, we had a pretty high agreement by the end of the scoring process. We were all thinking along the same lines. And what I'm concerned about, what Brady said is, how would a third party who was not involved with this, who aren't involved in the day-to-day running of what the commissioners do and what the staff does, when they come back and they read these minutes, how would they interpret it? And that's why I wanted to be clear that the commission is not just overly delegating. And I have utmost confidence in the staff. And again, I'm sensitive to the time constraints. I have no intention at all of slowing things down or becoming an obstacle. And like I say, I've been monitoring these changes, and I don't think other chairs in the future would use this kind of language to get involved in sort of day-to-day management or over delegation. That's why I said major substantive changes. But I guess other people can interpret major substantive changes differently. But anyways, I'll let other commissioners respond.
So William, and then Catherine, then Corey, and then Dwan, just check me on the time when we need to vote, let us know that we have to vote, but Will.
Thank you, and thank you for the excellent discussion. On the precedent setting, I don't think it's particularly precedent setting because it's one committee deciding that this is how they would like to operate. And if other committees feel that that's wise, they will follow suit. And if they don't, they won't. So I'm less concerned about that, but I am sensitive to Jim's concern about appearances and how things are delegated. And I was wondering if I could get a question answered from Brady. Brady, my understanding is now that we are in the statutory language, we're in the state code, that as a sub-entity, the Board of Trustees could not just disband this commission on their own. It would have to be an act of the legislature and signed by the governor. Is my understanding correct?
Yes.
Okay. All right, then I'm less concerned about appearances, but I also don't think it's precedent setting, so I'm fine with either of these. Thank you very much for your time.
Thank you, William. Catherine.
So my question is maybe perhaps more technical. So the issue that came up is, for example, reporting rural was no longer required, but the committee had decided that reporting rural was important for California. So it's really a discretionary reporting topic. And as I understand it, the committee would not want the staff to eliminate a discretionary reporting topic simply because the federal government or DOF had decided that no longer was required. So I wonder if just on a more technical matter, if it just says to update, you know, like it's like required reporting topics, but it's like, or not do discretionary topics, right? So that if the committee said we really want rural and that's important, that would still go back to the committee before it was eliminated. So to me, there's a difference between what's required and what's discretionary that the committee still might want to weigh in on. I agree if it's a required, if it's like a deadline is easier. If they change a deadline, you don't really have a choice. And if they eliminate a category that the committee doesn't otherwise care about reporting, that seems fine. But if the committee were to care about a reporting topic, we shouldn't interpret the first one to give the staff the authority to do that without consulting with that committee.
And I think that's what staff was going for when they when we were going for when we phrased it, that the change would only be allowed without going to the committee if it was necessary to comply. So like if the federal government was like, good news, we're going to remove this reporting requirement for you, that would actually not trigger this delegated authority.
But I don't read it that way. When necessary to comply means if the federal government says to you, you don't have to collect rural data anymore, that's what you do to comply, right? You don't have to comply with that anymore.
But it's saying, sorry, it's saying this option one gives the opportunity, the authority to make changes only when necessary. So if the federal government says you don't have to do anything anymore, you keep doing it without action by the commission, because it's not necessary to remove something just because the federal government says you don't have to do it anymore.
Well, then give me a reporting topic that would be necessary to comply.
If there's a new reporting topic that we're not currently doing and they say you have to do this, then that would be a necessary.
Okay, so then can we just say new reporting topic that's necessary to comply, that you're not eliminating old ones?
Well, it's not a new, sometimes they're making a lot of tweaks to existing things to clarify changes.
So I don't think, I can't see anything ambiguous at all. Whereas the major substantive changes, I don't know what that means.
Yeah, or if they change it.
I'm not asserting the major substantive changes. I actually was just trying to find a way to be clear that if the committee had decided that there was some data that was useful for California, that couldn't be eliminated within that. And I don't apparently see the language quite as clear as you do, because necessary to comply, like if in a subsequent federal administration, they're like, we don't want you collecting data, you may not collect rural data anymore, you could still collect that data in California and not report it to the federal government. So there are odd things that different administrations federally say, we don't want you collecting data about immigrants any longer. That seems within the realm of possibility within some administration. And that would be like, you can't collect that and report it to the federal government, but the committee might say, understanding what happens to immigrants is in fact important, and we want you to collect it but not report it.
Catherine, would it be helpful if it said, because I think this would still capture, and Duan, correct me if this is wrong, it would still kind of capture what staff was hoping it would capture, it to say like, delegates the state bar staff the authority to add HP3 reporting topics and adjust deadlines when necessary to comply.
That was kind of what I was suggesting before. Adding new ones is fine. You have to do that, but before you start removing them, particularly if there's a change in administration that says we don't want you, we don't want to know about immigrants, for example, I feel like that should go to the committee. So I'm not trying to like make an unnecessary point. I'm just trying to be clear of like, part of this seems like making sure the committee's wishes about important data of California is honored, at the same time giving you the flexibility to quickly respond to something that is a new requirement that you have to respond to. So that's my suggestion.
Okay. Thank you, Catherine. And then Corey was next.
Yeah, I was basically, I mean, I have to say, I do agree with our Council Brady that it seems pretty clear to me. I mean, that this is limited to when staff must make changes in order to meet our state and federal requirements, in which case it would presumably need to be done quickly. If there is a way to add language that satisfies Catherine's concern, then maybe that's fine. But you know, when I initially raised my hand, it was to say that I was also involved in the Appendix I, and I very much appreciate Jim's concerns about appropriate delegation between staff and commissioners. I think that it's an important issue that we've had to deal with exhaustively in the past, and hopefully not so much anymore, as has just been discussed. But I do think this seems pretty narrowly drawn. Putting on my lawyer hat, seems like it's very limited as to what the staff would be able to do, and that it kind of it's the sort of appropriate thing for staff, because it's the kind of thing that needs to be done for compliance immediately. And if my concern with the major substantive changes is that I think it kind of almost detracts from the limited nature of the resolution, because it kind of suggests that staff could be making major substantive changes, when in fact they're only supposed to be making changes necessary for compliance. So I agree with some of the other people that I think that phrase might actually maybe muddy the waters a little bit, and make it less clear that it's a fairly narrow delegation.
And then next was, thank you, Varen. And then next was Erica Connolly.
Hi there. So actually I have sort of a question / I'm concerned about the vagueness of what in consultation means. So is the expectation that like the chair would get to have final say, or would there be a vote between the chair and whatever staff was discussing it? I guess in the second one, I don't understand what happens when, assuming we could figure out what a major substantive change is. I'm curious, I guess, as to what the vision was for what would happen next. Is it just that the chair gets to like listen in, or I guess I'm confused about, because then we have other issues about like, well, now you just have like one person from the committee who gets to kind of make a decision about what's going on with the staff. So that raises other questions for me. So I'm just curious about that.
So and Jim, if this is not how you remember it, by all means jump in. But my memory, because this came up during the January 28th meeting, and I think where we landed with it was staff would have to bring it to the committee chair to discuss, and then the staff could proceed. But if the chair were very concerned, presumably the chair would convene the committee to pass another resolution, like stopping staff from doing it or something. But it wasn't, if I remember correctly, it was like to discuss it and then and then staff would make the decision, but the chair would be on notice at that point and could try to intervene by reconvening the committee. I don't know if anyone remembers that meeting differently, but I think that's how I remember it.
Yeah, it would, if I thought it was a major substantive change, it's eliminating something that we needed, yes, the idea would be that I would bring it to the committee. I kind of like Catherine's approach. I mean, the thing that I was concerned about, I mean, we know what the committee knows what's being collected, and we're all in agreement with that. And if the feds want something in addition, I don't think that has to be approved by the committee. So if we're talking about the new reporting topics and her language in there, I would be happy with that, because then it would be read as, according to what Brady said, very narrowly, that they can't get rid of things that the committee's already got in agreement with. And it's all right if they're adding new things. If that's the interpretation, that as if you added new HP3 new reporting topics and deadlines would mean that you could not eliminate what the committee is understood to be collecting to begin with, then I would be happy with that because that covers my concerns.
Bonachet was next, and then after that's Jason, and then Dwan, like I said, just let us know when we need to
Yeah, I
bring
think
the
we do.
discussion to a close.
I don't know if Chris is still on, but I mean, I don't want to cut short discussion. But we must.
We do have Christian, so Bonachet, and then Jason.
I just, as a wrap up really quick, I don't know if we need to find a compromise here. I don't think that's the way to be looking at this. I think the staff has spoken, our general counsel has spoken, the language that currently is here on the first proposal matches and meets all the needs. Just to think about, you know, we're going to try to find a compromise so that potentially Jim and Catherine feel okay with this. I don't think that's the way we've ever operated in the past. I think, you know, we're getting clearly what the staff's suggestion is. We're hearing staff's recommendations and their concerns, fellow commissioners. We're hearing their concerns. So my suggestion is, and you know, it's obviously back to Rich and Kim, that potentially it's to look at the second proposal, whether it is we need to vote on revoking it, and then looking at the first proposal that was originally passed. I'm not sure exactly what the process is that we need to go from here, but I just wanted to underscore that, you know, this isn't about finding a compromise for our commission members, but to listen to what our staff members are actually guiding here.
Excuse me, I just want to say that we are getting under a time constraint for people who need to leave the meeting. So I don't know, I agree we don't want to cut the discussion short, but I think we might just need to take one or two comments and then follow the appropriate procedure on these two motions, these proposals.
So how many more comments would you like to take? The order, we have Jason, then Tammy, then Erica. And I think Brady, as staff, you would be allowed to speak no matter what here. So, just let me know if we'll go to Jason, and then if we have time for Erica, let me know.
Okay, I'll try to be really quick. I think I agree with the other comments about major substantive changes, and I think I agree with Brady that the language here is pretty clear. As far as hypothetical future administrations and the ad concern, I think that a hypothetical future administration could also bar HP3 related funding from reporting and gathering certain data as well. And say, like, as part of this grant, you cannot collect this data. And so in collecting the data, we'd be violating the rule, and then staff would still feel compelled to make that change. The only thing I might be able to offer if we were wordsmithing would be to change when to only to the extent necessary to comply. And that might make it a little bit more comfortable that, like, they're not going to go any more than necessary to be minimally compliant with whatever those changes are. But I think it's fine as it is. And if you want to make it a little bit more narrow, that might make folks feel a little bit comfortable.
That's great. Do we have time for at least one more comment, or would you like to move to a vote?
I mean, we haven't heard from Tammy. I think we should hear from Tammy. That would be helpful to get one more comment.
Thank you, Kim. I first want to say I appreciate the dialogue around this. I was not part of Appendix I, but I was part of that last meeting. And after the meeting, this did kind of sit uneasy with me, and largely around the major substantive change in the definition. And then I also gave some thought around the staff, and that this could potentially limit their ability to move quickly. So again, I just want to express my appreciation for everybody's thoughts. It's things that I was thinking about. I'm in the position that our first proposal, continues to meet our oversight obligation.
So Brady, correct me if this is wrong, but there's no need for the full commission to vote to force a committee to retract one of its essentially the committee recommended on accident.
No, what I was going to suggest, first of all, just to piggyback on Bonachet's comments, it's not a matter of not reaching a compromise, but that I think that with our interpretation and what staff understands how they would operate under this, Catherine's and Jim's concerns are addressed because of the way we're interpreting this. I would also agree that just to make things clear, I don't think it necessarily makes a difference, but probably in tone it does, to replace when with only to the extent necessary, only to the extent. I think it's technically the same meaning, but it just makes clear that this is a limited grant. And then, I don't think we need to vote on both of them. I think it would make sense to have a motion on one of them, and then if that one doesn't pass, we'd move on to the next. If one of them passes, then we presumably would not have a motion on the second. So that would be my suggestion for moving forward.
I'm glad to move the first proposal on the screen.
I'll second.
So I'm going to strike through this just for, oops, I didn't actually have to pop that out, just for clarities, so people know exactly what's going on. Okay, so this is and as Brady just said, if this passes, then we wouldn't be going to this one. Okay.
Christopher, this is Banasha really quick. Could you maybe read the proposal? Because we have people on the call.
Oh my gosh, that's such a good idea. Yes, of course. Yes, so the proposal is, this language is introductory language. So the proposal or the resolution begins resolved that the Legal Services Trust Fund Commission approves the changes to 2021 through 2023 homelessness prevention, HP2 grant reporting, and 2021/2022 through 2024 homelessness prevention, HP3 grant reporting, as described in staff's March 11, 2022 memo. And it is further resolved that the commission delegates to State Bar staff the authority to update HP3 reporting topics and deadlines only to the extent necessary to comply with state and federal requirements for coronavirus state fiscal recovery funds.
I believe Will moved, and I'm sorry, I missed who made.
Banasha seconded.
Okay, great. And I could do roll call vote. Rhinus?
Yes.
Savage?
Yes.
Schreiber?
Yes.
Vanarelli? Aglagi?
Yes.
Al-Saraf? Ball?
Yes.
Whitemaster? Bennett?
Yes.
Blakemore?
Yes, and I would like just to say that I would like a future discussion about what the role of the commission is in reaching decisions, because I really am troubled by the notion that one should not attempt to work with all the commission members to come up with language that works for us so that we can all feel comfortable with the decision. So that's just a request to the chair. I'm really pretty upset about the last conversation. So thank you for letting me say that.
Shelley?
Yes.
Connolly?
Yes, and I also think we should have a further discussion on the topic that Catherine mentioned, just to have some better, we work to compromise, I think, in these meetings. So I echo that.
Friedman?
Yes.
Galkin?
Yes.
Iskin?
Yes.
Judge Klein? Cruz? Lee?
Yes.
Mahoney?
Yes.
Meeker?
No.
Motion passes.
All right, thank you. That's the end of the agenda items 7A and 7B. And thank you for the extra time if we ended up getting more time than we were supposed to.
Thank you for staff getting us through this. Rich, we're on row numeral 4, I believe.
Go Bulldogs.
I don't know if we were just hacked or not, but if you're Georgia fans, that sounds like a good thing. Maybe Fresno. In response to Catherine and Erica's comments, both Kim and I wanted to have a full-throated debate about this, because while the topic is narrow to the HP committee and its purview, it is really a topic that generally applies to all committees. And the questions raised are profound and fundamental, and were raised 4 years ago, but I think we need more clarity, especially for the newer commissioners. So thank you, Catherine and Erica, for that. We have state bar reports. Juan, over to you.
Thank you. And I'm going to do A, B, and C in one swoop. And I'll try to keep it short. So a bit of good news. I wanted to announce some staffing changes in our office. So Chris McConkey, who just presented, and Michael Chang have both been promoted to the program supervisor position. Chris is going to be continuing to be the committee coordinator for HP, and Michael is taking, he has a background in auditing. He's taking lead in our building our fiscal compliance protocols and making sure we're in compliance with all the federal and all the reporting requirements, and all of our fiscal stuff is in line. Also, Crystal Bundang, who is the committee coordinator for partnership, and Erica Carroll, who is the committee coordinator for eligibility and budget review. They have also both been promoted to the lead program analyst. They'll remain committee coordinators for their respective committees. They'll also be undertaking some more policy work with our office. We also have some new faces. As you see, our grants have grown quite large, and so we've added a lot of new staff, and we're continuing to add. Colleen Seaton, I think I saw her, but she might not be on right now. She started a few months ago. She comes from a nonprofit background. She's a program analyst. Erica is supervising her. She's going to be primarily working on IOLTA EF and partnership grants. And we have on Heidi Slater, who's taking notes today. She is our new senior financial analyst, and she's going to be working very closely with Michael. We also have a new program analyst and a new program analyst starting next month, and we are about to make an offer for a program coordinator position. We also have 2 openings, so the office has grown. I mean, Elizabeth and I were just looking at the tree a few weeks ago, and it's grown about 50–60% over the last 4 years. So we're just really excited for the growth. We're excited that the legislature has trust in the commission and the staff and the state bar to entrust us with the funding. And as you can see, the staff is really remarkable and dedicated and hardworking. On to B, staff updates on grants administration, including your meeting materials. We have a list of our 2022 monitoring visits. We're going on about 40 monitoring visits this year. About a third of them have already been scheduled. We really encourage commissioners to go on at least one. They're also being conducted remotely. So if you can't participate for the entire time, you're welcome to come for a portion of the day. If there's any that works for your schedule or that you're interested in, just email me and I'll connect you to the staff lead on that, so that they can catch you up to speed on that program and meet with you in advance and talk over kind of maybe if there are issues or what they'll be kind of diving into. So again, we really strongly encourage you to attend. It's a really fun way to kind of learn about the work, hear about and meet people like Pablo, work alongside staff. It's a nice way for us to come together.
Duan, I just wanted to add to that. Many of you may not know that we commissioners have a responsibility with respect to our grantees to assist them when trouble surfaces. Staff brought to our attention problems with the San Bernardino grantee that Pablo leads today. He was not affiliated with it at the time. And we as commissioners, along with Bonnie Huff and other interested parties, made a holistic audit, including interviews with board members, and extensive interviews with staff, going to the site and actually watching the intake process. So our commission role is much broader than simply making these grants. The monitoring visits are a terrific eye-opener. So if you get a chance, please sign up.
And Eric, did you have your hand up?
Yeah, Juan, did you say that all the visits are going to be remote?
all the visits are going to be remote to further notice. So Bonnie and I usually check in every 6 months now in the midst of the pandemic. They used to all be in person. We used to go visit, bring out our program side, bring out our fiscal team, but they're all being done remote. So we'll revisit again this summer. But
so we want to sign up for one. What? Just let you know, or
yeah, just let me know. Let me know. And we usually, and it's not a limit, but we usually encourage just one commissioner per program, because programs feel like we bring along, they feel like for us, it's more of an educational process, and we don't want them to feel more anxiety than they need to. So if there's 2 commissioners that are interested, then I'll just ask you if there's another visit you might be interested in. But yeah, just contact me, email me. Okay, great. And my last update is on IOLTA revenue. So I have Michael helped me prepare 2 slides. So let me share my screen. See if I can get this bigger for you. Okay, so for the new commissioners, usually in June, that commission meeting is really focused on determining the IOLTA distribution for the following year. So I wanted to show you what you approved last June for 2022, so that you can have a sense of where we're going. So last June, you approved the IOLTA 2022 distribution of about 35 million. And then at that time, we were projecting to have net assets of about $11.7 million at the end of 2022. So you can think of that as our reserves at the end of about $12 million at the end of 2022. And I'm going to show you what we closed out 2021 revenue to look like. So at that time, we had projected that for 2021 revenue, we would be receiving about $23.5 million. When we closed out the year, we actually got $30.1 million. So this is great. We're about $6.6 million ahead of projection. So if you add that to our projected reserves for this year, we're about $18 million. So this is all really, really good news. I want to just stop here and see if you had any questions, and then we'll give you a little bit more of a forecast on what's to come.
Juan, do you want to just talk about the role of the reserve?
Yeah, so we really try. I mean, it's very difficult with IOLTA because, as you know, they follow interest rates, and as interest rates fluctuate, unfortunately, our distribution has had to fluctuate. So really, we try to use a reserve to smooth out those fluctuations so that programs can have some stable funding. We are one of the codification topics that's we're going to begin very soon is to look at that reserve policy. The reserve policy lays out this 4-step calculation when revenue is rising in order to kind of bank a lot of that revenue so that we can build up a sizable reserve. There's not a lot of guidance when revenue is declining like they have been in the last 2 years, and the commission is given this very big kind of a band of like what the reserve target should be, which is like, I believe it's like 30 to 75%, but there's not a lot of guidance where it should land. So we definitely want to look at the reserve policy and see where we can update it. One of the preliminary kind of staff recommendations is to maybe think about a 3-year forecast and how do we save enough reserve so that programs can be insured grants for 3 years at a time. We think that maybe at a 3-year, that would enable hiring. Right now, if you look at kind of IOLTA revenue, especially in the last 12 years, you'll see there is those fluctuations that's not ideal for staffing and for hiring for programs. But that is what we use our reserves for, to smooth out in the lean years. Will?
Can you just remind me of total revenue last year?
Michael, can you help me with that? Michael, you're on.
Yes, let me take a quick peek and we will definitely get back to you on that.
Okay, it's not vital. I was just trying to get context for how big of a drop it was.
And the one missing piece here that we'll have for you, let me stop sharing my screen, that we'll have for you at June meeting is what the projection for 2022 will be, because that will definitely impact and be probably one of the most important factors to help you decide what 2023, I'm sorry, what 2023 distribution is. You know, I don't know if you've been following in the news, but the Federal Reserve has signaled that it is set to raise interest rates at least a few times this year. So we know interest rates are going to go up. We don't know how much they're going to go up. Even if they go up 50 basis point, the next time they go up, that might make that's not going to really make a meaningful difference for our revenue, because right now with our leadership banks, the floor right there is 68 basis points. So even if they go up to 50 basis point, it still doesn't reach our floor. What we think, and Elizabeth and Michael are really, you know, help really hold down the IOLTA compliance side of it, and working with our national consultants, is that even with the rate increase 3 times this year, 2 times this year, we're not going to really see that meaningful difference until 2023. But still, a good direction if they start raising. It's just we won't see the impact of that until.
And I would just add that there was a lot of positivity for interest rates to be for interest rates to go up this year, and that was before what's happening in Ukraine right now, and so that will also have an impact. So we don't have a good sense for the time being.
Yeah, and on that note, I think the direction from the Fed earlier this year, before the war took place, was in the March meeting, the anticipation was a 50 basis point increase. But now I think more recently, within the last couple of weeks, it's really been signaled to be maybe half of that. So potentially just 25 basis points, not more, but somewhere in that neighborhood. So we'll definitely know more following the meeting later on this month in terms of overall direction from the Fed. And then just to answer Will's question, looking at one of our prior slides that we presented last year during the projections discussion, we also had presented a recap of the 2020 actuals. And your question was with respect to total revenue actuals. Last year, Will, it was 36.2 million was the figure.
Wow, so
That's the IOLTA figure.
thank you.
Sure.
Eric?
Just wanted to remind everybody that, because every time we talk about IOLTA, we maybe don't always keep sight of the fact that IOLTA is only part of the picture here. EAF is another very, very big and maybe becoming even bigger part of the overall funding picture, right? So when we think about how much money we will have to distribute to QLSPs, we really kind of have to keep the whole picture in mind. And last year, I mean, EAF and IOLTA, I don't know, my sense was that they used to be sort of equal. I could be wrong about that, but now EAF seems to be like bigger and bigger and bigger and bigger, right? And is the legislature even thinking about more this year?
We're hoping. So by the time we meet next time, we can give you a better sense of whether it's likely, and maybe I think the budget passes, Selena, you might know better, in June or July. So it might be time so that we do have an indication of the EF numbers. But what I'll try to do is create kind of a slide to show you what all the streams of funding that are coming through the commission, because Eric, you're right, it's the, you know, the comprehensive picture is really important when you go to make a determination for IOLTA. Selena?
Yeah, just to respond to Eric's question, the Access Commission and LRAP are meeting with legislative staff now, urging an increase in Equal Access Fund, which we are characterizing actually as level funding, because it was last year. We're hoping to make that level funding instead of a one-time. And so far, it seems like we may have some traction. It's just really complicated because of the state budget this year with the surplus and GAN limit and all of that. But we will know with the May revise whether it got into the governor's version, and then we won't know for sure final until the final budget passes, which happens in June and then is signed later. But you will likely have an idea about how likely a measurable increase is in Equal Access Fund by the June meeting.
And then for the new commissioners, what we do for you in June is we give you a kind of a conservative estimate for what our revenue is for 2022, a moderate and aggressive, and then the commission will decide on first, you know, what projection to use, and then secondly, based on that projection, what the 2023 IOLTA distribution is. So we wanted just to preview that to you and tell you that that was at least very, very good news to close out 2021 with $6 million more. Great, and that's the end of my report. I'll hand it back to you, Kim and Rich.
Okay, so we are on to,
Numeral 5.
all right.
Okay.
Kim,
This will
you're
be-
up.
Right, this will be very brief. I think everyone by now has seen the committee assignments. The date of the matrix was March 3rd, 2022. And so hopefully everyone knows what committees they are on. The newest committee is the nominations committee. And I can tell you right now that there's really no agenda item on that. We have a meeting the end of March. Even though you are not on the nominations committee, I just want to put in a plug for the fact that we would love to hear from you as to any recommendations for applicants for the commission, either commission members coming through the public process or through a state bar appointment. And back to the committee assignments. The only update and change, which I'm happy to report, is that Tammy has agreed to chair the Bank Grants Committee. We're very happy about that. So that's it for me on Roman numeral 5, so we can keep moving forward.
And Kim, Rich, I just want to bring to your attention that Judge Klein, our new commissioner, has joined if we want to do introductions.
Okay, Rich, I think you were going to do.
Judge Klein.
Are you here?
Your presence is welcome. I hope you'll signify that you're here.
Yes, as soon as I unmute, I will.
Welcome. It's good to have you join us, a legislative appointee. And this was your first commission meeting, so we're very pleased to have you join us. The material we've discussed gives you, as you listen to it, I think an overall idea of what the commission does. But as meetings go on, I think the mystery of all this will be cleared up. And your committee assignments will certainly help and do that. So welcome. We're really pleased to have you join us.
Apologies for being late. I had a long-standing commitment on a seminar I was hosting for the LA court. So, in any event, it ended. I'm here for the rest of the meeting.
All right, we are on Roman numeral 5C, I believe.
5B, I believe.
Yeah, Chris and Dwan.
No, 5B is Erica and Elizabeth, who will be doing an update on the LRAP working group.
Right. There was a considerable amount of material on LRAP if you had a chance to review it beforehand.
And Elizabeth and Erica, we're running short on time, so maybe if you can keep it to 5 to 10 minutes, if that's okay.
Sure, absolutely. I'm just going to bring up the PowerPoint quickly. So as Rich mentioned, we shared with you a memo for our working group, our loan repayment assistance program strategy working group that's been meeting over the past year. I don't know how much of an update has been given at prior commission meetings. I know we have some new members, so I'll just kind of quickly go over the history of this working group. So we've been meeting for a little bit over a year with members of different bodies associated with the state bar. So we have members from the Council on Access and Fairness, members of the commission, so Bonochet or Catherine, if you want to weigh in on anything, please feel free to jump in. Also the California Access to Justice Commission, and then with the support of state bar staff on this working group. So myself, Chris McConkey, Dwan, and Elizabeth Hom. And Brady has also been helping us with some of these efforts. So the purpose of this working group was to get together and start to brainstorm ideas to address the loan debt crisis that many law school graduates are experiencing. You may have seen figures like attorneys are graduating from law school with a median debt of about $165,000 nowadays. Upwards of 90% of graduates are carrying some amount of debt. And this is impacting recruitment and retention, particularly in legal aid and public interest positions. And so the group wanted to think about ways to support loan repayment assistance efforts or loan forgiveness alternatives. Including one topic that we looked at was public service loan forgiveness, which historically has not been a very effective program, but has undergone changes in recent years and months to make it more effective. So we researched those alternatives. We've explored other models in healthcare, which does both scholarships and loan repayment assistance to incentivize doctors to work in underserved areas, as well as to support individuals from groups that are underrepresented in the health professions. We also looked at public and private funding for LRAPs. And last June, we conducted a survey of public interest attorneys in California about the nature of their loan debt. So what types of loans they hold, their balances, what their repayment options are, and whether they're seeking public service loan forgiveness. So over the course of all of these working group meetings over the past year, what we've been working on most recently and what we met with the working group this week to discuss was a proposal for a state bar administered loan repayment assistance program, which is sort of in its early stages, in the inception stage. So we're still working out some of the details, but really the goals or the impetus behind creating this proposal, first and foremost, was to support the state bar's mission, chiefly to support efforts for greater access to and inclusion in the legal system, focusing on strengthening recruitment and retention in public interest positions to reduce turnover, addressing disparities in loan balances that negatively impact diversity in the legal profession. So, one data point that we came across in our research was that attorneys of color have a median loan debt that's usually between $30,000 and $35,000 higher than white attorneys at graduation. And in our research through the survey that we conducted, we've also seen that attorneys who've graduated in the past 15 years or so, very few of them have seen any reduction in their loan balances. In fact, most people have seen them increase. So we wanted to find ways to directly address those disparities. We wanted to reduce barriers to attaining loan repayment assistance. There are other existing LRAPs, but they often have pretty stringent requirements, and they may exclude a number of attorneys from eligibility. And then we also wanted to make sure that we were trying to create a proposal that would complement other LRAPs rather than be exclusionary in any way. So. When we met as a working group earlier this week, these were some of the proposed program requirements if we were to implement a state bar administered loan repayment assistance program. We discussed all of these points, and they may change again, but wanted to share with you sort of the initial proposal that we did share. For example, we decided to focus on nonprofit attorneys rather than, say, government or government and nonprofit in order to have a smaller applicant pool to get this program started and underway, and particularly focusing on nonprofit because that is the sector that's most acutely impacted with turnover these days. We recommended higher income limits than you might standardly see because, again, we saw a lot of attorneys excluded from, say, their law school LRAP because their income increased and they could no longer qualify. We also wanted to streamline that process for them. Wanting to tailor any payments that might go out to the actual amounts owed. So needing verification of loan balances and monthly payments. Again, making it broadly applicable, so not requiring specific loan types, that it could either be public or private loans, as well as undergraduate and graduate loans. Requirement to exhaust law school LRAPs, just because those are a pretty longstanding source of funding and are a major source of support, so that the funding from this program would be available to individuals who don't have that option. Again, up to $15,000 a year, just to make this as inclusive as possible. One thing we learned in our research was, if you don't have federal loans, obviously you can't qualify for public service loan forgiveness. And you may not have an income-based repayment plan, and so you may owe a lot more on a monthly basis than what you might standardly see with income-based repayment. Also, some parameters, just if the funding were to not meet the need to make sure that we're making the funding impactful. So having the ability to make proportional reductions in payments as necessary. And then this last point that I have an asterisk on was a suggestion to structure the payments as a forgivable loan. I put an asterisk because we're still looking into sort of the requirements for that, but the idea behind that is there are certain ways to structure forgivable loans so that the borrower doesn't have to, typically it would be considered taxable income, but there may be ways to have that excluded from taxable income, and that way it's maximizing the loan repayment assistance that the attorney is receiving. That way it's not cutting into the funding and they're not paying taxes on it. So that's really a key point that we are continuing to look into, but we're optimistic about. And we spoke with the working group about this. We got some great feedback, and we're going to be continuing to refine this, but these were sort of the initial parameters that we shared with the group. So having had that meeting this week, State Bar staff is going to undertake some next steps to move this process along. We're developing a plan for initial funding. So the State Bar has projected that it could contribute up to $5 million to initiate this program. We're exploring whether additional funding would be available from the legislature. There is a statutory loan repayment assistance program. I neglected to mention that before. It's not currently in operation, but we're looking into the status of that program, whether it might get up and running. As I said on the last slide, establishing program parameters, assessing cost, looking into what kind of data points we would want to measure impact and reach. So ensuring that we'll be collecting data and analyzing it. And then needing to establish an advisory committee, which would provide the oversight for any loan repayment assistance program that the State Bar would administer. So I know I ran through that pretty quickly. Happy to answer any questions.
And I would just add, we are still, in the stages of planning. And so we're still, ironing out the details and what it would look like to administer a program like this. So there's nothing set in stone. And there's still much discussion with the working group to be had to move this forward. So we just wanted to present this to you as an information item.
And Rich has his hand up, Elizabeth America.
Yeah, Rich.
I thought there was something quite odd in your report that at page 8 described the public interest attorney loan repayment program, which has $1 million in funding that has escheated from IOLTA funds. And that struck me as being strange, that IOLTA funds could actually be escheated, and why those funds haven't been put to work for their intended purpose. So can you give us some background on that?
So I think it was maybe 5 years ago, the statute related to LRAP for attorneys was amended to allow escheated IOLTA funds to be put into the pool for the LRAP, and that's currently to be administered by the Student Aid Commission. The Student Aid Commission, however, has not taken the steps to transfer those funds from the Controller's Office to their funds, and they have not initiated the LRAP program for attorneys at their office. We've reached out to the Student Aid Commission to let them know of our interest in standing up an LRAP program, and I believe Donna will be talking to them shortly.
So how does the Student Aid Commission take $1 million of IOLTA funds?
So this is,
it was by statute.
To be clear, this is not, the IOLTA statute gives us the interest on operating accounts. This is abandoned accounts that are where the principal's escheated to the state, just like
thank you, Brady.
If you died, your bank accounts would have no estate to take it over.
Right.
Eventually, the state would take those funds.
Okay, thank you, Brady.
No problem.
And Corey, I think
Corey, did you have your hand up?
Corey, did you still have a comment? No.
Yeah, I was just interested when it said the proposal is for State Bar funding for that that $5 million. If you could just explain like which fund.
Yeah, so there are plans for the State Bar to sell their San Francisco office, and so the proceeds from that office from that sale, we anticipate that anticipated sale would be, we would set aside $5 million to as seed money.
Thanks.
Brady, did you have a comment? Or was this a response? Okay, great.
Okay.
Does it, and before we end, I just really want to thank Erica Carroll for being the lead staff on this and doing all the research. The memo that you saw in the packet wasn't the only memo that she's drafted in regards to LRAP. She's explored many options. I also want to thank Eric and Bonachet, who have been part of this working group on behalf of Legal Services Trust Fund Commission, and also to our partner organizations, Access Commission, as well as the Council on Access and Fairness. There's just been a lot of work and a lot of meetings, and Brady, who's now doing a deep dive in tax law and figuring out all this exemption stuff for us. So thank you all.
Thank you.
Oh, and Bonachet has her hand.
Oh,
I just wanted to really quickly note, it was probably 2 years ago where we began having conversations to join efforts and have more partnership with kind of our sister commission inside of the Office of Access Inclusion, which is COAF. And so this engagement allows us to be working more one side of the office with the other side of the office on a needed initiative. And then of course we're at this point partnering with Access Commission, where Catherine and Jim, and I think we have one other access, Judge Jaskell, also sit. So this is a nice collaboration for, as I said, a very needed initiative.
thank you, Bonachet. And just to clarify, the Council on Access and Fairness is the sub-entity at the State Bar that helps advance our diversity, equity, and inclusion strategic initiatives. So, Will, you have a comment?
Yeah, this is really cool. I had a question and or feedback on the eligibility requirements, and I was wondering who I could direct those to.
You can share them with Erica directly.
All right, thanks, Eric. I wasn't going to do it now.
Okay, Elizabeth. Erica,
no,
anything
later.
else?
No, that's unless there's any other questions, I think we're done. Thank you.
So we'll move on to 5C, Kim, and it's Chris and Duan, I think.
Yes, this is a really quick update. Chris, go for it.
Yeah, so this will be a little bit of a refresher because you've heard some of this before. So you may recall that there was an assembly bill, I think probably in the fall of 2020, it was AB 3362. It amended the Business and Professions Code for 2 years to increase by $5 what we call the opt-out donation to legal aid, and it earmarked that those $5 opt-out donations from attorneys when they pay their annual license fees for legal services organizations and support, QLSPs and support centers to hire provisionally licensed lawyers. And the whole program was only is going to last for the $5 increase was going to last for 2 years. And it was set to expire on January 1, 2023. Well, the legislature is now considering making it ongoing and rolling that. Now, the provisional licensure program that gives those license is actually set to sunset this June. So the legislature is going to roll that $5 if it continues to support this. We'll roll the $5 into the existing donations to legal services that goes out by IOLTA formula every year. So it's going to keep the $5 increase, but it will no longer be earmarked to hire provisionally licensed lawyers because that program will have ended. And so the Office of Access and Inclusion is convening representatives from this commission, the Access to Justice Commission, and some other key stakeholders like LRAP and California Change Lawyers to talk about if there is a unified position that they can pitch, that these groups can pitch to the legislature that would be a targeted strategic intervention investment of those funds that would be even better than just distributing it via the IOLTA formula every year, which just means it just becomes part of the regular IOLTA grants that everybody gets, but something a little bit more strategic. And so that working group, that like strategy group has yet to meet. It's going to meet next week, but some ideas that have already popped up, and I'll just kind of list a few and then I'll turn it over to Duan, see if she has anything to add, but some ideas that are already floating around are things everything would increase or otherwise strengthen legal services directly or indirectly. So there are things like increasing pro bono opportunities via something like a statewide pro bono portal, helping legal services orgs build their internal infrastructure to provide natural disaster or other disaster legal aid, improving technology for remote services, outreach and education, delivered remotely, probably to remote communities, fellowships, summer fellowships for law students, and then what I kind of think of as like legal services, one step removed, things that would strengthen the legal services or improve them, things that would support the organizational health of QLSPs and support centers to help strengthen, the sort of like internal financial expertise, DEI resources, wellness programming, and the like. So those are some ideas that have just kind of floated around, and this strategy group hasn't even met yet, but they're like already thinking about it. I don't know, Dwan, if you would add anything.
Yeah, we just want to give you a sense of the revenue amount. We're estimating about $800,000 per year, so not a large amount, but also not insignificant. And I also want to thank Rich and Kim, because this idea of pursuing kind of a legislative change to keep the $5, Rich and Kim had thought about it. And when our executive staff had reached out to the legislature, they had already had it in mind too. So it was really a great meeting of multiple minds.
That's great. Thanks for mentioning the amount, because that $700,000 to $800,000 per year is based off of now the 2 fee cycles that have elapsed. With the $5 going towards hiring provisionally licensed lawyers. We now have the 2021 and now the 2022 state bar attorney fee cycle have closed. And so we've projected that that's the amount of money that's come in every year. And there was a sense, I think, that if you just take that $800,000 per year and kind of distribute it among like 100 plus nonprofits, the impact might be a little less, well, it disperses it throughout the state, which is great. The impact is a little less, or at least maybe less measurable than if it's targeted toward a very particular pillar of support that would also be statewide, but more niche. And Danielle.
I just wanted to flag, I believe Judge Klein had a comment and was kind of visually indicating that he wanted to speak, so I just didn't want to lose that.
Oh my gosh, thank
Judge
you.
Klein, please.
You're on mute still.
Judge Klein, you're on mute.
What is what was the term?
A provisionally licensed
provisional licensed lawyer, and do the legal services organizations want that instead of funding for a licensed lawyer?
Great. So I think the procedural history was the state Supreme Court authorized a time-limited program called the Provisional Licensure Program that was a pandemic measure. They started at the beginning of the pandemic, and it's set to expire this June. And it was a way for law students. It started as a way for law students who were graduating during the pandemic to get a provisional license to practice. They had to have a regularly licensed attorney supervisor that was their sponsor, so to speak. And as long as they met all the other criteria for a regular license, they could get a provisional license before taking the bar exam. So the legislature wanted to support that and increase the opt-out donations on the attorney license fee statements by $5 to support that program. But since that program is set to expire in June, the legislature wants to keep this increase, but we have to find a new use for it. And so if the legislature stays the course, it'll just go out by the IOLTA statutory formula. To answer the very last part of your question, my understanding is about 20 legal services organizations, QLSP, Qualified Legal Services Projects and Support Centers, did apply for what we called the Provisional Licensed Lawyer Grant, which is what that $5 went to pay for 2 years. 20 of them applied. There was greater demand for PLL grants than there was availability of PLL grants. So demand exceeded supply. And we have yet to have them complete their final report, but I expect that they'll come back and say it was a great experience and the PLL contributed to their services in really meaningful ways, and it was a good thing. But they won't be able to do it anymore.
Why would they want that instead of a lawyer, unless it's they can hire more, they're cheaper?
Oh, I think the that question never really came up at the commission level or even the legal aid level, because the legislature wanted to do something for law students that were graduating during the pandemic. So I think that was a
Even though
not
this
a
is after the
live
pandemic.
question. Yeah.
All right.
Yeah.
Selena.
Yeah, I would say it's not an instead of. There's we have a recruitment retention crisis in our state, and especially during the coronavirus period in which so many people were working limited hours, caregivers were unable to work and couldn't carry as much caseload. This was a really amazing opportunity, and the idea originally came from legislative staffer to say, can we create a fund to help all of these people who are graduating from law school and don't know when they can pass the bar exam and get a job? Can we create something so that at least a small portion of those folks could be employed at legal aid? And I can speak for legal aid programs, I'm sure Chris can too, is that it's been an incredibly popular program because organizations can hire folks who it's all about the exam, basically. They have all the skills, they went through law school, they just weren't able to take the bar exam because of COVID. So it's both. We like lawyers and provisionally licensed lawyers.
Yeah. And now that program is sunsetting, as the pandemic hopefully continues to wane, the legislature fortunately is eager, thank goodness, to keep the increase, but needs to find a new use for it. So essentially the placeholder language, I don't know if that's the best way to characterize it, but ceteris paribus is, if nothing happens, it's just going to go out by Ulta formula, because that's the current delivery mechanism for those opt-out donations on the attorney license fee statements. But there is the opportunity to pitch to the legislature something more targeted for that $5 increase that they want to make ongoing.
Chris, correct me if I'm wrong. These are grants in the range of $50,000 to $60,000 a year.
Yeah, so that when the $5 was earmarked to hire PLLs, they ended up being there were about 20 of them, and they ended up paying for most of the provisionally licensed lawyer salaries, payroll taxes, and benefits for somewhere between like a year to a year and a half. The programs got to pick the start date and end dates for their PLLs. And I think they were in the range of like $60,000 to $70,000 on average. It's been so long since I looked at them, but that's about right. Some programs had to kick in a little bit of their own funds. The full commission delegated to its executive committee the administration of that grant. And the executive committee made the decision to mostly pay for the salaries, payroll taxes, and benefits, but to get each program to kick in like a little bit, so they had some quote skin in the game, and they could squeeze out a few more awards that way. So I think this was just a FYI report. The strategy group will meet next week on Monday, I believe, and so we'll go from there. There's no resolution for this agenda item.
All right, let's move to 5D. And Danielle.
Great, I will share my screen, and Dawn and I will be presenting this together. So Dawn, feel free to jump in at any time. And LAC has also been involved. So I would invite Selena as well to jump in where appropriate. Just making sure I'm sharing the right one. Great, okay. And then we'll do slideshow from beginning. Okay, so today we wanted to talk to you all about a new funding opportunity that is coming to the State Bar and the Commission, and it is coming from the California Housing Finance Agency, or CalHFA, or HFA, excuse me. And so today I'll go through what this funding opportunity is, the background, and the expected grant parameters. I will say the grant parameters are still being finalized because we are still working on the contract and scope of work with CalHFA, but those are very, very close to final. So I'll present today what we expect those grant parameters to be. And then also we'll go through the timeline that we hope to get approval on today in terms of distributing these funds. You'll see it as a very short and very quick timeline. And then I have some resolution language for you all to react to and potentially vote on if you'd like to move forward today. So the background here is that California Housing Finance Authority received $945 million through the 2021 American Rescue Plan Act to launch a California mortgage relief program. And that program is designed to help homeowners who have fallen behind on their housing payments due to the pandemic and related financial hardships. That program at Cal CalHFA is primarily providing financial assistance and covering past due housing payments for those folks. I believe it can pay up to $80,000 per household, and they're hoping to serve between 20 and 40,000 folks. But one of the authorized activities for this kind of broader mortgage relief program is that some of that money can be used for legal aid services, and CalHFA would like to do so. And so they would like to subgrant 12 million of that 945 million to the commission and the state bar to administer as legal aid foreclosure prevention grants. So to really leverage the commission and staff's expertise in administering civil legal aid grants. They felt that we could serve as an effective intermediary, if you will, for those funds of the 12 million. And they would like to get those funds distributed as quickly as possible. And the fastest timeline that staff felt was doable was to administer them for those grants to start on July 1 of this year, which is a very short and speedy timeline, but felt that that was kind of the shortest that we could do in meeting CalHFA's desire to get those funds out as quickly as possible.
And I'll just add, in the kind of meetings and negotiations with CalHFA, it wasn't just state bar staff. I represented the state bar staff, but Rich and Kim also participated.
Yes, thank you. And so CalHFA, state bar staff, and then our representatives from the commission are still finalizing the scope of work and contract terms, like I mentioned. We feel like we're very, very close to getting that finalized. We're still kind of tweaking with the language, but that's largely set. It's just not signed yet, if you will. But the expected contract terms is that these funds would be available to QLSPs and support centers. They would like the funds to be 2.5-year grants or 30 months from, again, July 1 of this year through the end of 2024. Because CalHFA wanted to get these funds out as quickly as possible, but July 1 was kind of the earliest staff in the commission felt, or executive committee felt that that was doable. One kind of compromise, if you will, was that we would allow programs to charge expenditures to their grant back 1 quarter, back to April 1 of this year. CalHFA would like them to be competitive grants, so it would be an RFP process. And CalHFA has agreed to allow up to 8% for administrative fees for state bar staff time and committee and commission kind of oversight of those funds. Any of that we would not spend if we did not need the full 8% would go back to programs, would be distributed to programs as part of their grants.
And I'll just give a little bit more context. We've been speaking to CalHFA for a few months now, and they actually had wanted us to try to distribute it in a shorter time frame, perhaps 2 or 3 months. And Rich and Kim and I talked at length, and really the quickest we could do it at that point was 4 months out, so making July 1st. We wanted to do a quicker process, but we didn't really want to sacrifice the integrity of how we distribute grants and to do it responsibly with some commission oversight and proper kind of review of the grants, and also on the staff side, we wanted to be a manageable workload for the staff as well. So 4 months was really the quickest we thought we could do it, and we were unwilling to shorten it to their kind of desired. They had requested about 2 or 3 months.
Let me add to that it's not simply a matter of apportioning the $12 million to various applicants. It is also defining for them the kind of reporting that has to be done in order to meet the guidelines of the source of the funding. So that's all got to be designed. CalHFA was not designing it for us. And it's pretty much done internally by the commission, by the staff, actually. So it's more complicated than you might think.
And one compromise that we did make if we decide to go forward is even though the grants start July 1st, we would let award recipients expense reports back 1 quarter to capture those qualifying expenditures if they happen to have engaged in that. And we did say to CalHFA, we do this for all of our discretionary grants. If it's moving towards a direction that they may be receiving a grant, we would let them know so that they can gear up to make the job postings and start their infrastructure and be geared up to receive the funding in July 1st. And Judge Seligman and then Kim.
Yeah, whose idea was it that it had to be competitive? Because in the bank grants, we had a combination of formula and competitive, and we have a lot of experience on foreclosure prevention background. So whose idea?
I don't know who it was exactly, but I did float out, if you wanted it under the 2 or 3 months, we could definitely do it through formula.
Yeah.
And I can't remember what entity or who actually said it, but the state bar side was, we could do it on formula, but it was a no. But I did offer a formula as a quicker way, because we know with the formula, it would be a more simple application. Then we wouldn't have to review. We just make sure that they're qualifying and then run the formula. But oh, you know, one of the main reasons is some of the smaller programs, they wanted to allow them to have a bigger project. I think that was one of the more compelling reasons I can recall.
Is there a mandatory grant size maximum or minimum, or is that part up to us?
That CalHFA has not did not impose that. Our suggestion, because grantees, applicants like to have some sense so that they're not, you know, is 2.5 million. That will be the proposal that would be brought for approval. It's 2.5 million cap. It's a high cap, but it gives them something to design around. Kim?
Actually, I'm going to let Lauren, who has her hand raised. I think you wanted to respond to Judge Sellerman. So why don't you go first and then I'll make my comment.
Thanks, Kim. Yeah, I was just going to respond to that question about why not formula. I think that there's such a small proportion of programs, relatively speaking, that do the kind of work that qualifies for this funding that formula didn't make as much sense. Lisa Sitkin at the National Housing Law Project and I have been working for some time to coordinate folks that have programs to provide mortgage prevention legal services. A lot of those are programs that used to be a lot bigger, kind of went away, and now are needing funding to get started back up again. So we anticipate that it'll be 12 or 13 programs that apply. And by the ability to do an RFP, they can really plan for the few years that the funding will last, budget it out, and ask for how much money they need to make that happen.
Okay, yeah, I was going to also give you that number that there's a very small number of programs that are going to be able to use this money. This is pretty exciting for the Trust Fund Commission because we're working with a new estate entity and establishing a relationship with them, and then the potential for future funding to help on home ownership opportunities. I think there's a lot of possibility on that. And just sort of thinking sort of globally about this. I mean, if you're reading anything in the newspaper about reparations, there's a lot of discussion about the importance of home ownership and passing on that home ownership and the wealth through home ownership, owning land, to the next generation. And so this is a really, I think, important funding opportunity, and I'm thrilled that we're going to be able to work on it.
Lauren?
I just wanted to quickly underscore something that Kim said about the great potential of this relationship. As a little bit of background, when we got money from the National Mortgage Settlement, the Trust Fund Commission got about $30 million to distribute. At the same time, from the same fund, CalHFA got $300 million, and they were using a lot of that money for housing counseling services. And so LAC reached out to them at that time to figure out where our goals aligned, what kind of relationship we could build, and started back then really showing them the value of legal services. So they're an entity that the government knows can help people, homeowners and renters alike. And now they understand the value of legal services. So I would just absolutely underscore what Kim said, that there's a potential for more money, not necessarily just for mortgage services, coming this way in the future.
And we've been working really closely with them the last month. We have weekly calls with them, and they've been just a true pleasure to work with. Danielle, Chris, myself have been on those calls. So we've been able to, start to establish those relationships, meet a variety of their staff over there. So it's really a great agency to agency partnership.
Yeah, and just to underscore something that is maybe implied, but just to say it out loud, I believe it was Lauren mentioned that, or maybe Kim, that 12 to 15-ish programs is about what we're expecting to apply, which is why the maximum award amount is kind of so high in comparison to the amount of funding. So it's 12 million, approximately 12 million in funding, and we're considering a 2 or $2.5 million kind of cap, and it's because of the relatively few number of programs we expect to apply. And so again, still ironing out the details, but as it stands now, and we don't expect these to change much, if at all, the permissible activities that grantees would be able to undertake with these funds would include outreach and education on homeowner assistance, grant application process, arrearage payments, foreclosure process, homeowners legal options, loan modification assistance and loan modification denial appeals, negotiation, mediations, and litigations regarding mortgage service violations, protecting home equity from judgment liens, as well as addressing existing judgment liens, and so forth. I won't necessarily read them all out loud to you, but I can pause here for a moment so you all can kind of digest those on your own.
And as you read, I just want to, there's two things that we're still negotiating with them. One is a pending question on whether ancillary services related to mortgage prevention would be qualifying. So for example, a homeowner comes in to get help on a reverse mortgage or so forth and has related bankruptcy or consumer law, would that also be? And I think the tentative answer is yes. We just need to confirm that. We also asked whether policy work would be qualifying, and it's federal funding, so there's an explicit requirement of no lobbying. So now we're trying to figure out, is there anything that's policy work that's not lobbying related? And they're willing to hear like kind of our argument. So those are kind of the things that may be added. I don't think this list, there's going to be any removals. If anything, there will be things that will be added to this list. One other thing about eligibility in terms of for clients. They use a different income threshold than we do. As you all know, we're at the 200% federal poverty threshold. They're based on AMI. Right now, to qualify under their program is the 100% AMI. They've told us that they think that actually might change to 150 AMI. At 100 AMI, as you know, AMI is based on per county cost of living. So depending on what county it is, the 100% AMI may be close to 200% or 200%, and some counties is actually significantly higher. At 150, we haven't ran the numbers yet. We're going to do the analysis once we get the green light from them. Probably would be considerably higher. So the one thing for our grantees to keep in mind is though they can potentially use this funding to serve 150% AMI, that difference between 200% and 150% AMI, they'll have to deduct it from their qualified expenditures for IELTS and EF purposes. So it's just something for them to keep an eye on, our grantees. We don't want them, because of these grants, to then be their IELTS funding to be jeopardized. So we'll provide that TA and make it really clear. Another thing, and I can't remember if Danielle has a slide on this, because these are federal funding, there is very robust kind of reporting requirements. One of the requirements that for their close to $1 billion that they received is that these funds have to target socially disadvantaged communities, and they have a really specific definition of what that is. They don't use, usually for us, a lot of our legislation has said rural and underserved, and we have now defined a really good definition of what rural is. They don't use that measure. It's just a different metric. So that is something that we will have to educate our programs. So just there are things that we need to work out, but it's a great opportunity. And Eric, I'm sorry, did you have your hand up?
No, you answered my question.
Okay, great.
Great. Okay. Well, I will move to the timeline. As you'll see, it's a very quick timeline again, hoping to have the grant period start on July 1. And so kind of moving backwards from there, we would need to release the applications in late March to give programs about a month to put together their applications, and then also another month or so for staff to review those applications. And the dates that are highlighted here are those that have changed slightly from what the executive committee saw at its February 15th meeting, and or changed slightly from what is in the memo. These are not substantive changes, it's just we finalized some dates that weren't finalized at the time. So again, we previewed this opportunity to the executive committee last month. Because of the short timeline, staff have already been working to draft the request for proposal, the grant application, and the scoring rubric that would be used to evaluate those applications after they come in. We're still finalizing the contract with CalHFA, but hope to have that done in the next few days. And so today you all are meeting to discuss and approve the distribution timeline and delegation of authority as you see appropriate. We plan to have an informational webinar for grantees on Monday, March 21st. And then if the commission agrees with the executive committee's recommendations, which I'll go through in just a moment, the executive committee would meet later that same week to approve the request for proposal and the scoring rubric. And again, that gets us kind of through application release and application review for that grant period to start on July 1. So what was outlined in the memo and what was discussed at the executive committee level and is before you for consideration today is some delegations of authority that would allow us to get these grants out by July 1st. The first point of this, or the first part of this resolution rather, is approving the timeline that I just showed you. So as outlined in the March 11th, 2022 PowerPoint presentation. But then the second bullet point really gets at the delegation of authority. And what the executive committee is recommending here today is that the commission delegate authority to the executive committee to approve those requests for proposals, including the scoring rubric at that March 23rd meeting, and delegate authority to staff to score the proposals in consultation with commission co-chair Kim Savage. And that was because the staff and the executive committee didn't feel that there would be time for both a committee and the full commission to review and approve the RFP, and then also to review and approve the actual grant amounts and awards. Eric, I saw that you had your hand raised, but then lowered it. So to your question.
Yeah, it's back up. I'm just rereading the resolution. So I'm sorry, are you proposing to delegate authority to the executive committee both to approve the RFP, and you may have just said this and I missed it, and to approve the proposed winners and losers, essentially?
No, it's two pieces. So the first one is correct, Eric. The executive committee would would approve the RFP and the scoring rubric, and then separately, staff would have the delegated authority to score it, and it would be in consultation with our co-chair Kim Savage.
Well, when you say score, you mean select winners, essentially.
Yeah, exactly.
Okay.
And I will actually exit out of full screen just so I can amend this language if needed. But yeah, I will open it up to, Dwan, if you had anything additional to add, then open it up for discussion.
I don't have anything to add. I see Will, I think it's Will first, and then Jim, and then Chris.
Jim was first.
Oh, Jim, I'm sorry, Jim, go ahead.
Oh, okay. Well, I just want to, I'm a little concerned about how we're changing different approaches to the discretionary grants. I mean, first we used to have subcommittees review all of the grants. That was found overly burdensome. Then we had subgroups of the subcommittee read subsets of the grants and then get together and score them. Then we went to the scoring team approach, where we had the subcommittee calibrate the rubric, and then you had a subcommittee or a scoring team of which the chair was a member, and then staff score all of the proposals and then go back to the subcommittee with any problems or disagreements. And now I'm not exactly sure what you mean in consultation. Does Kim, are you going to score all of these grants along with staff like we did at the homeless prevention and we did for the partnership, or is the staff going to score it on their own and then just come to you with the scores that they have for you to review? I mean, exactly how is that process going? And I presume the executive committee is not going to have a calibration meeting to see how they would apply the scoring rubric. And I presume it's not going to go, the final, or this executive committee will not be discussing problematic grants. It's just that they're going to approve what Kim and the staff came up with. Is that how it's going to go?
Not approving it.
Kim, Rich, I'll let you respond to this one from Jim, please, if you don't mind.
No, it's fine. Kim, do you want to weigh in on this?
Well, quite frankly, it was not my idea to be called out in this. The overall approach is based on this time constraint that we're under. So the idea was to have the executive committee involved as opposed to setting up another committee, referring it elsewhere, and coming all the way back to the full commission. So I consented to being the person that the staff could consult with as necessary, but it frankly was not my idea to do this. We wanted to make sure that the approach, this expedited approach we came up with was something that the commission could feel comfortable with. And we thought that an executive committee of 4 people, current co-chairs and the next round of co-chairs, that would give the full commission the confidence that the 4 of us working with staff would do the work with integrity, and we've all frankly got a lot of experience having been on the commission. But I am certainly open to other possibilities, including the idea of replacing my name with that of the executive committee.
Yeah, I just added that two items that have been mentioned. One is this is intended to enable staff to do this in a streamlined fashion. And the emphasis here was on how quickly we could get the funding out, because CalHFA made it very clear they wanted funding out, if possible, in 2 months. As Dwan mentioned, that we deemed that to be impossible in order to meet our responsibilities in terms of grant making. And so streamlining the process was intended. And I think, Jim, this is somewhat a reflection of the discussion that we had with respect to the resolution we debated a few hours ago, it seems, with which put the chair of a committee, your committee, in the same kind of role. So just those kinds of comments. I see 3 hands raised, so we'll go to you, Will, and then after that, Bonifay and Catherine.
Thanks, Rich. If you'll allow it, I have a couple clarifying questions. I'll try and make them really quick. We're talking about $15 million.
12 million.
$12 million. This will not be an ongoing funding stream. This is a one-time.
This is a one-time, yes.
Okay. So normally we would form a subcommittee and delegate that authority to the subcommittee. But because this is a one-time $12 million pot, the feeling is we want to expedite and go against that regular process of delegating to a subcommittee and just go for it, give it to the executive committee who's already been involved. Is that a fair characterization?
Just one correction. Usually the subcommittee does the work and then brings back that recommendation to the full commission.
And so this won't be coming back to the full
This will not be coming back.
So this would be full delegation to the executive committee to, will it be coming back to the executive committee?
It won't be coming back to the executive committee. That's why
Gotcha.
I don't want to speak on behalf of the committee, but I think what the committee said was to make the commission feel more comfortable. They suggested including one of the co-chairs in that.
Okay, all right. Thank you for those clarifications.
And then I believe it's Bonifay, Catherine, and then Joe.
Thank you. So just a couple of questions. I'm absolutely sensitive. I think we all are sensitive to getting this money out and obviously meeting the timeline that's before us. So how we can do that, I'm in support of. My only, and I think I know why Kim Savage's name is on here. It's because she is a and she will say this, usually if you're a master at something, you don't say you're a master at something. It's usually those who aren't masters who say they are. But she's an expert and a master in housing law in the state of California. So I can see why we would put her at the helm of this. But may I suggest that this is the executive committee as the body of four, rather than just Kim's name there.
It's gonna be, can I respond to that? And I just want to be completely honest with you all. When I talked to Kim and Rich and doing it in the 4-month timeline, it could only work if we delegated it. It will be a hardship for staff to roll it back to the committee and have the committee score alongside staff. I made that abundantly clear to Kim and Rich.
We always have Bagley Keene to keep in mind as well.
That's true. That was my only comment. Thank you.
Catherine, you're on mute.
Yes, and I'm working hard to get off of it. So I think I might still be confused. So we approve the timeline, the only involvement of the executive committee is in approving the request for proposals that people are going to submit, not the proposals themselves. And there's no commission involvement in scoring the proposals or approving the proposals. And I don't quite understand what consultation means. It seems like one of those words that is unclear, much like we discussed, as someone said 2 hours ago. So I have been a supporter of the commission doing this, but I really feel like the commission should have some involvement in approving the grantees, because that is the commission's role. And I don't think I'm comfortable, like, I don't know what consultation means, but I don't see any place that the commission is approving the grantees. And I would be fine if it's the executive committee, or if that doesn't work because of Bagley Keene and you have an executive committee member and 2 other members that do it, that complies with Bagley Keene, then I would encourage that.
Joe?
Catherine just said everything I was going to say, which is that I think that some group of us needs to be involved in the actual approval, deciding who gets how much money. I don't think we can appropriately delegate that final decision to the staff, as terrific and thoughtful as they are.
Jason?
Dissimilar comments, and I also would draw some contrast to the last discussion on a similar kind of delegation question. I'm wondering if we could change the in consultation with to just having Co-Chair Savage be part of the scoring and delegating to staff and Co-Chair Savage to do the scoring, and instead of that being consultation. And then there's at least representative from the commission actively participating in scoring. I know it's a lot maybe to take on. I'm just thinking about other contexts too.
I think if we have 2 of the Brady, are you still on? If we have 2 of the executive committee, are we still? He's not on.
It's less than majority, I thought.
Yeah, I think that still works. But let me.
That's right.
Oh, wait, Brady's back.
Well,
Brady?
so I mean, it depends. If we're creating a new group and delegating authority to that group, that'll be a Bagley Keene.
That'll be a Bagley Keene. Okay.
Yeah.
Corey?
Oh, I was just kind of going to say something similar to what Brady had said, which I think if that's what people want to do, is have a commission member involved. I think instead of consultation, it would have to be just a delegation of authority in order to be clear. And I was going to ask Brady, although I guess it's already answered, whether it's, because I think in some circumstances it's possible to have 2 people, but I don't know if that then creates a quorum. So I guess it does. But yeah, I think I don't see another way procedurally to do it and have a commissioner approve the final results and meet the timeline other than delegating it to somebody to be the deciding person.
Brady, we couldn't delegate it to or a different word, but to both the co-chairs. Would that work somehow?
No,
No.
because once you, so there's that whole, I know people have the 3 or more in their head, but that's for an advisory body. This is, you're actually delegating power. So if you're delegating to more than one individual, it's a delegated body. Except
I can make a suggestion too that might work, but I don't want to cut in the line, so I'll wait.
Okay, Chris, Will, and Judge Selden.
I was just going to make the sort of friendly suggestion that Danielle, you should feel free to not take, which is if it looks like there might need to be another meeting of the executive committee or something, that just before everyone votes on it, maybe tab back to the timeline slide and just see like where that will fall and get a sense of like, does that shave a week off of the time to apply, or maybe it shaves a week off the time for them to sign their agreements, just so the commission has, they're like, okay, they see like what the repercussion is. I don't remember exactly, you know, at the executive committee when it looked really carefully at this timeline, exactly what it thought about each time period, but I just remember it felt really tight in that meeting. But anyway, if that's not helpful, don't worry about doing that.
No, that is helpful. Thank you. And I will just flag quickly before we go back to the order of comments that I believe in the memo we said if it needed to go back to the executive committee, for example, if staff and Kim disagreed or wanted additional commissioner input, we could potentially schedule an additional executive committee meeting. I think in the memo it said early June was kind of floated as an option. But I will turn it to Will.
We're all on the same train, I think. It would give me more comfort, I'll speak for myself, to have the executive committee approve, if not score, give final approval to the grant allocations and review that for any changes that may be necessary. And if that isn't possible, because it looks like there's a little window in there where it could be possible, and it would be fairly pro forma, I assume, but it would allow the vice co-chairs and the co-chairs to have an opportunity to review before finalizing the grant amounts, if that's possible. If not, let me know.
I think Judge Seligman and then Kim.
Yeah, I would say ditto. I think it should be a quick approval by the executive committee. It looks like you could squeeze it in there. I know it's a hassle, but I think the delegation is very problematic.
Go ahead, Kim. Kim, you're on mute. Kim, you're on mute.
Yeah, I agree. I think that if it can come back to the full executive committee for approval, that would be fine. And
so I was going to make that suggestion, but I do need a clarification, because normally with the committee work, you split into review teams and do it. If we do that, we cannot do it, and the staff won't be able to do it under that timeline. But if it's purely convening the executive committee and you review our recommendations, then that is doable. But if we split into review teams, we cannot do it. We will not accept the funds from CalHFA. I'm just going to put that out.
No, I was not suggesting that at all.
Because
I'm
I just have to
suggesting
underscore
the former, that it just come back, that the executive committee review and approve the determinations that staff has made.
Because I and I understand that your oversight responsibilities. I do have to, I want to reiterate again and underscore, when I had the conversation with Rich and Kim, I said we could not do it if we split up into review teams, and they were confident that the commission would be persuaded. And so we've been working 12-hour days to make this happen. We've been bending over backwards in order to get these funds, in order to distribute it. I am unwilling to then say to the staff that have been working 10, 12 hours, myself included, if we're going to be breaking up into working groups and having them work 12, 10 hours during that review period for that process. I just want to make that really abundantly clear.
So just following up on that to make it clear, really all we're saying is that the executive committee will approve the RFP. Staff will score it and submit it to the executive committee for approval, period.
Okay, great. And then so we'll call that meeting, and I think we did have in the former version, Danielle, you're right, a placeholder for that meeting.
Looks like Jeffrey still has a comment.
No, I think Judge Ligman just said exactly what I was going to say. I only have opposite. I don't like to see a motion that calls out a specific commission member. I don't think that's appropriate. And so I would say in consultation with a commission co-chair, and as far as the schedule and the executive committee approval, I agree. And Dwan, I don't want to see you guys have to go into separate teams. I recognize and appreciate the time frame that you're being asked to do this important work. And I think it's important that we streamline it while at the same time making sure it has proper commission oversight. So I think the way you have it on the screen now is exactly how I would like it, and I will make a motion to approve based on what's on the screen.
It's actually not in consultation. It's just the executive committee now. So Danielle, I think the tweak would be delegate authority to the executive committee to approve the grant determinations. Does that?
Do we still?
Yeah, I think the consultation language is irrelevant.
Yeah,
so
it's just
I'm fine with or without
committee.
it. I think what's important to me and what I'm hearing from other members is that there is a final approval by the executive committee, which hopefully you can schedule that meeting now.
So it's just, Danielle, to delegate authority to take out to staff, to executive committee to approve the award determinations. And let's not put the scoring there, because then I think that confuses.
To review and approve?
No, just to approve, because
Okay.
review might signal. Like,
And we still need to tool with the timeline itself before we make this motion. But I just want to make sure we were all comfortable with this language before I am flipping back and forth between slides. But Chris has his hand raised.
Oh, I should have lowered it. You just said it, Danielle, out loud, which is that the top part of the resolution references a specific timeline referenced on a slide. And to the extent that the bottom part of the resolution changed something, just make sure it doesn't conflict. The way you've worded it in this table may not need any changes.
Do we still?
Yeah.
Do folks?
No, yeah, so that's take out just staff score application, not in consultation, and then add a line that says it'll have to be in June, and maybe we leave that flexible. It's June right now. Executive committee meets to approve grant awards.
Yeah, I think you could literally even just put like to be determined date or something like, or like June 2022.
Or early June 2022.
Oh, don't say early, just say June because.
June 2022.
Yeah.
And this is executive committee to approve grant awards.
Yeah.
Okay.
So I know we're still going through discussion. I'll just say that I reaffirm my motion with that change to the timeline.
Brady, can you just take a peek at that motion, make sure it works? And Catherine, I'm sorry, go ahead.
I actually would feel more comfortable if we said consider and approve. It's not ministerial. It's the role to consider the applications and approve them. So I appreciate they're not scoring them. I'm not suggesting any of that. I just don't think it's ministerial. Like, I think
maybe we change it on the motion then with that. I think that might be better.
I was speaking of the motion. Thank you for clarifying.
To delegate authority to executive to consider and approve. Yeah.
Thank you.
Of course.
I'm fine with that change.
So is it implicit in the delegation of authority to the executive committee that the executive committee can come up with whatever process it wants to actually score the proposals? I mean, what I'm concerned about, I mean, I don't know that we need to mention Kim by name in the resolution, but just as a matter of process, I do think it's important for some commissioner to be involved, not only in the ultimate approval, but also in the scoring.
There are two, if we go back to the timeline, you'll see there are two entries for executive committee involvement, March 23rd and to be determined in June.
Well, we welcome Kim to score them alongside us. If you, it seems like Kim doesn't want to be put in the motion. I don't want to speak on her behalf, but I think that's what she said.
No, I'm not necessarily, I'm not suggesting that. I just think, and this is a kind of a comment that I think Jim made earlier, and it may come up later in the connection with the partnership grant process. I do think there is value in having at least a commissioner involved in the scoring process. in the hands-on scoring process. Because once the staff gets through the scoring and submits its approval, its recommendations to whatever committee you're working with, it becomes a bit of a summary process, and that there is value in having some hands-on commissioner involvement in the actual process. So we don't have to change the resolution. I'm just expressing that opinion, that process opinion.
Jeff, did you have a comment?
Yeah, I understand what Eric's saying, and I have great appreciation for the comment, but this is what we have staff for. And I'm comfortable with the executive committee being the designated body to review the RFP and to review the rubric. And I have trust in staff that as they have issues and concerns, they can bring it to the executive committee, and all of that would be considered as part of the final approval.
I'm glad to second this motion with that informal understanding that Kim will still get to be involved with her expertise.
Great, okay, I'll do roll call. Rhinus,
Yes.
Savage,
Yes.
Schreiber, Vanarelli, Aglagi,
Yes.
Al-Saraf, Ball,
Yes.
Fightmaster, Bennett, Pamela Bennett, Blakemore,
I'm sorry, I tried to get in before we started voting. Is a commission member scoring this or not scoring this? It's like with this informal understanding that Kim can, I'm now back to being confused about what is happening. So I can just abstain because I don't know. Jeff said one thing and William said another thing. So I don't know. I honestly don't know which of the two we're approving.
I was motioning for the what is on the screen and echoing what the staff had said in response to Eric.
So
My
I read
understanding
what's
was
on the
that-
screen to say that there is not the commission involved in scoring. That is,
I believe on the timeline that the commission through the executive committee is involved in the approving the RFP
yeah,
and the rubric that would be used.
yep.
And that also that committee will be the final approval of the grant awards.
I understand that. That's not what William said. He said there was an informal understanding. I thought that that Kim or others would be involved in the scoring. And I guess I at least wanted to be clear so that we all know what the agreement is we're voting on. It seems important. So if I'm the only one that's confused, I'm happy to abstain. So I'm not trying to hold up the vote. I just wasn't quick enough on the unmute to raise this before.
My understanding was that it wouldn't be in the motion formally, but maybe Kim, I'm sorry to put you on the spot. Do you want to just be involved and then we can make it into a motion, either in the motion or you let your fellow commissioners know that you'll help with scoring?
I am happy to work with the staff in consultation. It was not my idea because I don't like the idea, as Jeff had said, of just calling out a specific commissioner in a motion. But I am going to go with what the commission decides, and I'm happy to be involved at that, deeper level. I will carve out the time to do that, certainly. I also get Catherine's point that if it's going to happen, but there's some understanding, but it's not in the motion, how do we deal with that? It makes it a little bit unclear. So I will go with what the commission chooses. I don't have any problem being involved in it at the level that was initially discussed.
We can Danielle, would you mind going back? I'm sorry. So what we can do, if you all feel comfortable, is we can say,
we also could change it in the timeline, like put in consultation or some language in this, since you're also approving the timeline.
but
If
what I hear
people
is,
don't feel comfortable.
I think people want it in the motion because that's the more formal.
Which is perfectly
No,
legitimate.
actually, we don't want it in the motion. We're actually saying this motion, the way it's written, is what we are comfortable with. I think what Will may have done is just kind of had a little added statement that he was wishing for, but it's not necessarily what he was seconding. I think it's
Yeah.
starting to become too more complex than it needs to be. I think it was more of a side comment that he was making, and that perhaps we won't be doing that anymore, and just either seconding and stopping. If this is when we needed Bob Planthold, and he would be saying, listen, you just second it, you don't add anything further. So I'm going to channel Bob here and say that's possibly what Will was doing, but that this is the motion that Jeff moved and Will seconded, and now we've been voting on it.
And Jeff, Rich, and Joe have a comment.
So I just want to point out that it has consider and approved in the language. That was a change that we made earlier, which in and of itself defines the fact that executive committee is going to need whatever they need to be comfortable with what's being recommended. And if that means the involvement of a commission member or member of the executive committee to be able to get to that point, then that's at the discretion of the executive committee.
Yeah, I want to, if you go back to the timeline, my idea is that the executive committee on March 23rd would, if in its discretion it deems appropriate, appoint a member of the executive committee to participate in the scoring.
And Joe, did you have a comment?
Joe's occupied right now.
Okay. So Catherine, we were at your vote.
I'm going to abstain. I'm still
yeah,
confused. I'm
okay.
so sorry.
Okay, no problem. Will, sorry, Basheli?
With apologies for the confusion, yes.
Okay.
Sorry.
Connolly?
Yes.
Friedman? Friedman, Corey, are you still there? Galkin?
Yes.
Iskin?
Yes.
Judge Klein?
Yes.
Cruz? Lee?
So this is Lee, and I apologize. I had to take a call, and I think I had my hand up, and I think I missed the discussion. When I left, we were debating whether the motion we got to put back in the language that says that the staff will score, but in consultation with a representative of the executive committee, and I favor that. I think similar to Catherine's point of view.
Would you, what Rich had said when you were on the phone, Joe, was the executive committee is actually going to be meeting on the 23rd. At that time, the executive committee could delegate authority to a fellow committee member, perhaps Kim at that time, to score with the staff.
I see. I just think it's better to, if that's what's contemplated, I think the motion should reflect it. So I didn't agree with deleting the language about delegating to the staff the scoring. I think we should be transparent about how this process is going to work.
We're in
So I don't
mid-motion.
think you can't.
So
That's worth it now.
yeah, we're mid-motion. So Brady, can you give us some advice?
Okay.
Do we finish the vote, or do we do over and
Finish the vote and people can abstain, I'm sure.
Okay.
Yeah.
Is it okay?
Unless somebody wants to withdraw that.
Yeah, I apologize for throwing the proverbial monkey wrench. I'm not sure what, I guess I will abstain then. Thank you.
Mahoney,
Yes.
Meeker?
I just want to note that with this resolution, now that we have 4 distinct different approaches to how we actually run these discretionary grants. And each approach has its own advantage in terms of reliability and validity. And each one has its own advantage in terms of how much is delegated. And so I guess in light of our earlier discussion, fewer of the commissioners are concerned about I am is going on the record of over delegating. But I do wish we have at some point, either the rules committee or the commission as a whole have a further, more detailed discussion of these different approaches and what we should adopt in the future when we get this kind of money dropped in our lap for quick distribution. But in light of the current circumstances and in light of the earlier vote, I'll vote yes on this particular proposal.
Motion passes. Thank you, Jim.
Thank you all. And I will delete the original motion slide just so there is no confusion at all. That is the motion language that you all voted on, and I'll save that as such. Thank you.
Just to make it even more confusing, but for those who have abstained, as a member of the executive committee, I want to commit to you that the issue will be raised at that meeting on March 23rd as to whether or not we should be appointing someone to participate, one of the 4 members to participate in the scoring. All right. We could use a bio break if people are of a mind. It's been a while. I don't think we're that far from the finish line, but in order not to lose anybody for those purposes, should we take a 5-minute bio break? Eric's nodding yes. And Dan is in agreement. Is that all right?
And I have to leave in a few minutes to go to another phone call, so I may or may not be back when you get back. But thanks for a good discussion today. Appreciate it.
Thank you, Catherine.
Thank you, Catherine.
Thank
All
you,
right.
Catherine.
See you in 5 minutes.
And sorry, sorry for prematurely ending the
I
debate.
think we can do it in 50 minutes.
All right, let's begin again. I'm certain that those who were given 5 minutes will join us very quickly. Thank you all for being so prompt. We are going to skip number 6. Is that correct? Because it was really included previously, and move to partnership grants.
Correct.
Yep, we're skipping 6 because the nominations committee, unfortunately, we had to cancel the meeting earlier this week. So we have that rescheduled, so it'll come back on the agenda for the June meeting.
All right, on your agenda item, Roman 8.
Okay, thanks. Hi, everyone. Chriselle Bendeng here, Lead Program Analyst with the Office of Access and Inclusion. I'll be reporting out on 2 agenda items regarding partnership grants. The first is approval of a late 2021 partnership grant budget revision request. And the second is the approval of recommendations for partnership grants 2.0 funding. Both of these agenda items will require committee or commission vote and approval, and I'll have those resolution slides, but we'll provide some context beforehand. In terms of agenda item 8A, approval of the late 2021 partnership grant budget revision request, Chris provided some context in terms of our general budget revision process, in which the different percentages based on the variances of the budget revision, which is different than a carryover, those that are over 25% are elevated for the commission to approve. The deadline for the 2021 partnership grant budget revisions was October 29, 2021. And for the most part, all of the timely submissions were approved by the commission at one of its meetings in 2021. As an update, San Luis Obispo Legal Assistance Foundation submitted a late budget revision request on November 12th, 2021. So this agenda item is seeking solely for this late approval, just so we're following process of the budget revisions. Here is a description of the budget revision and the explanation provided by SLOAF, which is their acronym. The overall budget revision percentage, which is a sum of the budget line item deviations, is 63.7. Generally, the commission has approved budget revision percentages because it mostly allocates monies. In this case, SLOAF has spent down the money, and the budget revision is really to reflect the money spent, especially in the personnel items. They had intended to hire a paralegal, but rather hired a clinic coordinator and also spent additional attorney hours and monies for this proposed project.
The committee looked at the explanation, and their recommendation for the commission was to approve the late budget revision. I'll pause here if there's any questions. Otherwise, I have the resolution on the next slide. Okay, hearing none, I'll have, here is the recommendation on the screen, which is for the commission to approve the Partnership Grants Committee's recommendation regarding the late 2021 Partnership Grant Budget Revision request.
I'll move that we approve the resolution as stated on this slide.
I will second.
I'll do roll call. Rhinus,
Yes.
Savage. Kim Savage. Kim, are you back? Schreiber. Vanarelli, Aglagi,
Yes.
Al-Saraf, Ball,
Yes.
Fight Master, Bennett.
Defer to my colleagues.
Sorry, is that a yes then, or no? I'm sorry. Yes?
It's a yes.
Okay, thank you. Blakemore?
Catherine said she had to leave.
Oh, okay. Bushelli?
Yes.
Connolly?
Yes.
Friedman? Galkin?
Yes.
Iskin?
Yes.
Judge Klein?
Yes.
Cruz? Lee? Joseph Lee, are you still there? Mahoney?
Yes.
Meeker?
Yes.
Motion passes.
Great, thank you. Moving on, this is more of the substance of the partnership grants updates. I understand that there has been past discussion about discretionary grants in the process. I will just want to highlight we have an item on the agenda in the Rules Committee. So I'm talking specifically regarding the approval of the partnership grants 2.0 funding and providing the review process just as more context for the commission. Just an overview of this. For this funding opportunity, there is approximately a little bit over 3.88 available funding. As a reminder, during the 2022 grant year, additional funding was made available because the 2022 partnership grants process had already concluded and the review process had concluded. We issued a new funding opportunity called Partnership Grants 2.0. Applicants were subject to the same threshold eligibility requirements, also providing continuity for 2022. We utilize the same scoring rubric, and applicants provided two options. The first was for current 2022 grantees to seek supplemental funding for a shortened grant period of 9 months, April through December 31st, 2022. The intent was for applicants to sort of be fully funded if they did not receive their fully requested amount. Option 2 was open to all qualified legal services projects to propose a new application or substantial expansion to an existing project. Because of the nature of that project, that was a 21-month grant period with a recommended funding range of $75,000 to $300,000. Just a reminder of the scoring rubric categories utilize a selection criteria, which was 80 points, funding priorities 20 points, optional innovation, which was up to 10 points. Again, PG 2.0 utilize the same definitions and descriptions as identical to the 2022 partnership grants because of that supplemental funding option as well to provide continuity and consistency. In terms of the proposals received and the total amounts you see on the chart there. Again, total amount available was a little bit over 3.88 million. The total amount requested exceeded the amount available at a little over 4.7 million. Considering the breakdown of option 1 versus option 2, option 1 we received 11 supplemental applications which totaled a little over 206,000. Option 2 was the bulk of the proposals, which totaled a requested amount of over 4.5 million. We received 17 new applications, which is pretty unheard of in terms of partnership grants generally. So that was a very positive sign. quickly going over this for option one, as I mentioned, we received 11 applications totaling a little over 200,000. Those ranges were much smaller because they were seeking supplemental funding to make them whole in a sense. So it was from 4 to 40,000. In terms of the review process, the Partnership Grants Committee delegated authority to an ad hoc review team comprised of both staff and the Partnership Grants Committee member, Christina Vanarelli. Generally, the reasons for requests for the supplemental funding was to account for increases in staff salary, and anticipated increases in a project's deliverables, or that the applicant or the grantee was making efforts to improve its current application and project. The Partnership Grants Committee looked at the explanations and was presented, and their recommendation was to approve all Partnership Grants 2.0 supplemental funding. I'll have this all broken down in a spreadsheet in this slide in just a few moments. Partnership Grants 2.0, we received 17 applications, again, totaling a little over 4.5 million. The supplemental amount was significantly higher. A lot of the applicants took advantage of the higher funding range. So it was from 119,000 to 300,000, which was the cap. For the review process for this subset, the committee similarly delegated authority to an ad hoc review team comprised of staff, as well as the committee chair, Eric Iskin, who reviewed and scored the proposals. We had an initial calibration in January, February, and then during that calibration, we scored 3 selected proposals, and the committee also provided guidance to the review team on how to apply the scoring rubric for the remaining 14 proposals. The review team then had separate subsequent calibration sessions and scored the remaining proposals and brought that back to the committee at its last meeting. Generally, the rubric score ranged from 68 to 98 points with an average score of 83 points, which really indicated a strong batch of proposals for Partnership Grants 2.0. The committee also considered the substantive areas that were covered, as well as counties served, striving for diversity in its funding recommendations. So I'll have the full spreadsheet in this next area, just to everyone has a few minutes to go over the different descriptions. Just to walk through the spreadsheet or screenshot of the spreadsheet a little bit, the gray under rubric score, these gray scores are the 2022 scores. Those did not change. Basically, those who applied for supplemental funding just submitted a pretty short application, just addressing if there were any maybe deficiencies or in any ways they were going to improve their project. And then their recommended supplemental funding, which you can see is that shorter, smaller range that I mentioned. The new applications are sorted alphabetically, so apologies if you're looking for a different order, but as you can see, the highest scoring project was 98 from Neighborhood Legal Services, Bridge to Self-Help Project, and our lowest scoring project was I believe, Neighborhood Legal Services, again, for the remote UD San Gabriel Valley. I did want to highlight that the committee is recommending to not fund 2 of these projects in the batch for the following reasons. As you can see on the list here, Neighborhood Legal Services submitted 4 proposals for Partnership Grants 2.0, all under for a requested amount of 300,000. So the committee considered the scoring rubric result, which was, a range from 68 to 98 for their projects. Also I think there were some concerns that there was overlap with one of the existing projects in terms of the substantive areas and counties that would be served. Another benefit was currently the 2023 partnership grants applications are available. So NLS, if you did not receive partnership grant 2.0 funding, they were recommended, highly encouraged to apply for 2023, which would only delay their project until the start of next year. The other project that was not recommended for funding for Partnership Grants 2.0 was UC Davis's School of Law Legal Clinics. both looking at the score, they scored a 69, and within the proposal, it was their project impact that was a deciding factor. I believe their project sought to serve 6 individuals, which was significantly lower when compared to the other projects that were proposing to serve hundreds or thousands of individuals. So thinking about project impact and the impact of the monies and the allocations, that's where the committee decided to prioritize. I'll pause here. There's a lot of numbers and I went through a lot of material. So if there's any questions, happy to answer that at this point. All right, I think I saw Pamela's hand go first.
Okay, you may have just answered the question, but I was wondering why there were such low numbers for funding for, is this family, I would say family services. There's like 4,000, 5,000, 7,000 for their award. So was there a reason for that low amount that they received, or?
Yeah, so under application type, these are supplemental. Basically, these are 2022 grantees. They already received funding for 2022. They were given an option to apply for supplemental. So for example, if a grantee applied for a $25,000 grant and only was awarded $20,000, they could have utilized option 1 and applied for $5,000. So all of these were seeking additional monies to what they have already received in 2022.
And they just obviously didn't want as much of the pot, so to speak, or no?
They were that was the caveat with option 1 is that they were only able to apply up to their requested their original requested amount from 2022. So that was a constriction. And if they wanted to do something more significant, there was option 2, which they were not. They were also open to apply for it. Like they were able to do that as well.
There are 2 courts I was affiliated with when I was a judge. Mental health advocacy. What is the mental health court clinic?
The mental health court clinic, and I will tap on Eric and any of the partnership grants review team who comprise of the ad hoc review team to chime in. It's been a while, and we're also getting the 2023 project, so apologies if I explain it incorrectly. But basically, this is a new project that's seeking to provide more holistic services to self-represented litigants in terms of social support. Oh, Dane has his hand up. I don't know if you were going to add on to MHAS's project.
I was just going to add to your answer. This is a new project that's being rolled out in Los Angeles, but I understand that Gavin Newsom has just talked about looking at introducing it in a lot of other jurisdictions as well. A court that specializes in addressing the concerns that are that come up with regard to people who have mental health crisis. Frequently, their concerns span both criminal and civil issues, and having a sort of a one-stop opportunity for them to resolve a lot of issues has proven very effective in Los Angeles, but I would defer to Judge Jaskell.
Do you want to call on Jim first? He was first.
Well, if it's the same answer, I don't know if Jim was going to answer the same issue, but
you're on mute, Jim.
Mine's a different issue, so go ahead, Judge.
Okay, so I'm now the LPS conservatorship judge in the LA Superior Court.
Oh, you're in Department 95. That's right.
Yeah, and they renamed us, so I'm now 103.
Yeah, I wasn't sure because I was also in delinquency mental health court.
Right. Oh, you did. Okay.
I started it. So what is that exactly?
Oh, so this is a legal clinic. Mental health advocacy services came to me and proposed this project, and then it was approved by the presiding judge, or the application was approved. And the idea is that mental health advocacy services will assist the people in the mental health court, and that includes competency cases as well as LPS cases, with issues external to their actual mental health court cases.
Yeah.
So various kinds of housing and other kinds of services.
Yeah, in the interest of time, I wanted that for years when I was there.
Yeah.
I don't mean to digress with everybody here, but I always felt there were a number of conservatorship cases where people did not have to be institutionalized, that they had some access to other types of services. And I was always hoping for paralegals, whatever, that we could do a lot more rather than, all right, enough of my editorializing. I'm glad to see something's happening on that.
Yeah, and I will say, Judge Klein, in addition, the meeting materials posted, there are the project profiles for each of these if you want to sort of read more about it. But I know we have a lot of the agenda, so.
Yeah, and I'll move on. I'm just delighted to hear that.
Thank you.
Because I always tried to get the public defenders to apply for grants, and they didn't. The other one I'm somewhat familiar with is they're expanding the guardianship clinic in public counsel. They were always way behind, and these people are always waiting to apply for guardianships. I also hope we would see that with the conservatorships from that setting. All right.
All right, Jim.
Sorry, I'm new. I'm just curious, but I'm delighted I asked that question from Judge Jaskell to hear that response.
Crystal, when the scoring team was getting together, did you do any sort of assessment on how much agreement there were amongst the team members versus the variance amongst the team members?
Yeah, so we followed, oh, Eric, go ahead, or do you want me to answer that?
We did standard deviations. We actually followed your model, I think, from, was it HP?
Yes.
So yes, we did.
Oh, good, because we had a lot of agreement, especially the grants that we proposed to fund. And the grants that we proposed not to fund had far more disagreements. So, which is comforting to know.
Thanks, Jim. And that's a reminder. I forgot to mention, we utilized the average points of 83 as a kind of the determination for the funding allocations. So projects that scored the average score or higher, 83 or higher, the committee is recommending to fully fund those 100%. Those projects that were scored 70 to 82 or below the average was a 85% allocation. Staff reached out to all of the projects just to confirm that they'd be able to operate with the decreased funding, and all of them confirmed it would just be a matter of slightly decreasing deliverables, but they were very pleased to hear tentative funding recommendations in support of their projects. All right. If there's no questions here, I'm going to just advance to the recommendation, which is to approve the partnership grants recommendation regarding the partnership grant 2.0 allocation recommendations.
So moved.
Second.
Okay.
Sorry, who's second?
Jim.
Jim. Okay, great. I will do roll call. Rhinus?
Yes.
Savage?
Yes.
Schreiber, Vanarelli, Aglagi?
Yes.
Al-Saraf, Ball?
Yes.
Whitemaster, Bennett?
Yes.
Blakemore, O'Shelley?
Yes.
Connolly?
Yes.
Friedman? Galkin?
Yes, sorry, missed the mute button.
No problem. Iskin?
Yes.
Judge Klein?
Yes.
Cruz? Lee?
Yes.
Mahoney?
Yes.
Meeker?
Yes.
Motion passes.
Thank you, everyone.
On the bank grants one.
It's Dan's up. Dan and Tammy.
Hi. I am a staff coordinator for the Bank Grants Committee, and on behalf of our new chair, Tammy Mahoney, I'd like to share a very brief PowerPoint. I think I can keep it to our 5-minute standard, but let's see how long it takes. Let's page down on this. Here's what we're going to talk about. One slide for each. What are bank grants? What have we funded and where are we now with this money? What money is currently available? What are our options for working with that money? How will we make a plan and what do we want to do? So it's a short agenda. The bank grant funds come from the settlement of federal mortgage fraud litigation and similar litigations against financial institutions. and they are limited for legal assistance for foreclosure prevention or community redevelopment. There is no income eligibility standard for services provided with these funds, but if our grantees do choose to serve over income people, they need to identify this as a non-qualified expenditure. So there's a little bit of administration on the back end, but the point is really that we got over $50 million of this money back in 2015 and 2016, and we still have some of it left. Here's what we spent so far, well, not spent, but distributed so far, approximately 46 million of about $53 million in grants in a number of multi-year grants that were partly allocated by formula, partly by a request for proposal process, but mostly by the request for proposal process. The last round of grants was allocated in 2020, and this is its last year of funding, $6.5 million, 13-year grants. They'll end at the end of this year. The biggest chunk of funds went out starting in 2018 and ending in 2020, $28 million worth of grants. And those had a one-year carryover period. After 2020, they had another 1 year to spend down any remaining funds. That period is now over, and we are in the process of getting reports back from those organizations on whether they spent all their carryover, and if not, we will invoice them for the remaining funds so that we know exactly how much is left to distribute when we decide to distribute the funds. In 2020 and in 2021, the committee recommended against making a distribution for various reasons, which I think if you look back historically kind of makes sense. This year, the committee met on February 23rd and thought once again that 2023 seemed premature for distributing funds, given the other funds that are coming into the picture and the status of, well, not the stat, I should say, the amount of preparation and advance work the committee wants to commit to a new distribution program. If we tried to do it now for 2023, it really just wouldn't be enough time to set up a focused RFP that could make a difference with this money. So the committee recommended, rather than trying to just give it away to the organizations that currently have the funds, just doing it by formula to everybody who qualifies, which would probably dilute the funds and make them not very efficient or effective. The recommendation was to hold the funds for 2023, but to start meeting later this year to develop a really solid proposal for the committee, the commission, excuse me, to approve next year for distribution in 2024. This would let us know for sure how much money we are distributing, and we would have a better sense of the best uses for those funds, given the chaotic world we're just beginning to resolve our way out of, and the additional evaluation reports that we're going to be receiving from all of our grantees within the next month or so. This was the committee's recommendation. I would open the floor to questions or for any further comments from our chair if I've skipped something.
No further comments. I think it makes sense that we would identify the remaining funds and do one final distribution, start planning for it in 2022 for distribution in 2024.
Thank you. Selena, is there a question?
Just a very short comment. A few organizations have reached out to us, and I would say that LAC agrees that this timeline makes sense, but a few organizations have reached out because they're concerned about having to stop programs that they'd hoped to reapply for funding. And so I would just ask that State Bar staff let programs who are currently funded, whose grants will end, let them know, so they can plan to use other sources of funding. But this, I agree, this seems like a good timeline because there's so much funding out now, and it gives a little bit of a breather for State Bar staff to both assess how much money is left, so you don't have to come back to this a year later.
Thank you. Hi, Dwan.
Yeah, thank you for that comment, Selena. So I think, Dan, what we should do is obviously reach out, but then really make sure the one that applied for foreclosure prevention, we can let them know about the CAL so that they can apply for that.
It's a good idea. Thank you. Just the bottom line, the bank grant committee wishes to get the commission approval for a proposal to hold the money this year, start meeting in September, develop a proposal and bring it back to you in about a year so that we can distribute in 2024. The resolution looks pretty much like this. Resolved that the Legal Services Trust Fund Commission will not distribute bank grant funding in 2023, but will begin planning in 2022 to distribute all remaining available bank grant funds beginning in 2024.
Mr. Co-Chair, I will make that motion.
Thank you, Jeffrey.
I'll second.
Who was that now?
Kim.
Yeah.
Thank you.
I'll do roll call. Rhinus,
Yes.
Savage,
Yes.
Schreiber, Vanarelli, Aglagi,
Yes.
Al-Saraf, Ball.
I approve, and Duan, I have to let you, I have to drop from the meeting in
Okay.
just a moment.
Thank you, Jeff. Fightmaster, Bennett,
Yes.
Lakemore, Bushelli,
Yes.
Connolly,
Yes.
Friedman, Galkin,
Yes.
Iskin,
Yes.
Judge Klein,
Yes.
Cruz, Lee,
Yes.
Mahoney,
Yes.
Meeker.
Yes.
Motion passes.
Thank you, everybody.
We are coming up on 20 minutes to 4, so I hope we'll be able to move quickly through the Rules Committee presentation.
We might need to cut one. The Rules Committee stuff does need a little bit more time we can shorten it a little bit, but we probably won't be able to make through all three. And we also have liaison reports, but.
And Amin is not with us.
Amin is not with us, but I'm prepared to do the introduction.
All right, please go ahead.
Great. So we have 3 items for the Rules Committee today. The first one is approval recommendations regarding late submissions. That working group is led by Danielle. Danielle has a PowerPoint presentation.
Okay, great. Thank you. I'll share that now. So good afternoon again. My name is Danielle McCrae, and I'll be talking with you all about the codification issue regarding late submissions of grant materials. The working group members for this codification topic are Catherine Blakemore and Erica Connolly. So this afternoon, we'll discuss the relevant governing authorities and issues or decision points related to this codification issue. I'll walk through quickly how the commission and staff currently handle or process late submissions. I'll then summarize the working group and Rules Committee recommendations. And then finally, I have a slide with proposed resolution language if the committee would like to move forward. I'm sorry, if the commission would like to move forward with the committee's recommendations today. So first, State Bar rules require that QLSPs and support centers that are seeking trust fund program grants submit a timely and complete application. Similarly, the rules require that grant recipients, those that are found eligible and receive funding, timely submit quarterly financial reports and other information reasonably required by the commission. The State Bar rules do not, though, define a timely submission or provide a lot of guidance on what to do if a submission is late. The one exception, the one area where the rules are more clear on how to handle late submissions is in relation to audited and reviewed financial statements. So as part of the IOLTA EAF application process, QLSPs and support centers must provide the State Bar with an audited financial statement Those are due on May 1 of each year, and State Bar rules allow staff to grant extensions up to the application deadline and allow the commission to grant extensions beyond the application deadline in cases of extraordinary circumstances. And so the issues, as you well know here, are that late submissions impact the commission and the State Bar's ability to administer grants effectively and efficiently. Late application materials create inefficiencies and delays in determining eligibility, calculating grant awards, and dispersing funds. Late submissions of reporting materials can hinder timely and effective oversight of programs' use of those funds. Additionally, most late submissions come in very soon after the deadline. So for example, in the latest IOLTA EAF application cycle, there were 6 applications that came in late, and 5 of those 6 were submitted within 1 hour of the deadline. But State Bar staff don't have the authority to accept late application materials other than those financial statements that I spoke of. There's also no penalty or accountability for programs who submit late materials beyond being subject to discussion and approval by the relevant committee. There's been some frustration, I think, at the committee level with programs that are repeatedly late, but then also a hesitation to fully deny those programs funding because they were late by, for example, an hour. And so the main decision points that the working group and also the rules committee had to deliberate were whether and when the commission should accept late grant materials, whether late application materials for discretionary and non-discretionary grants should be treated the same or differently, whether late application materials and late reporting materials should be treated the same or differently, and what, if any, penalty should be applied to applicants and grantees that submit late materials. And so I'll quickly walk through the current practice as it relates to late materials, and I'll start with application materials. And when I say application materials, that is grant applications themselves, the budgets, and budget narratives. And again, because staff don't have the authority to approve late materials, staff currently bring all late submissions, regardless of the length of the delay, to the relevant committee for discussion and approval. Committees and the commission have generally been pretty generous in accepting those late materials and again, have not assessed a penalty. For late reporting materials, State Bar staff do have greater discretion. Staff, the Judicial Council, the commission, its committees need the information that's in those reports. And so we have not typically rejected late reporting materials. State Bar staff may report late submissions to the relevant committee, but it really seems to vary by grant and report. So in an effort to create a more consistent and transparent set of expectations around late submissions, the working group developed and the Rules Committee recommends today a framework with which to evaluate late materials. So firstly, a submission that is not submitted and substantially complete, that is all the required and relevant questions are answered by the posted deadline, will be considered late. For those audited and reviewed financial statements, the Rules Committee recommends very few changes. They recommend staff maintain the authority to grant extensions up to the application deadline, and the committee or commission maintain authority to grant extensions after the deadline upon that showing of extraordinary circumstances. The one small change here is that there have been instances where the committee has struggled to kind of meet that extraordinary circumstances threshold, but didn't necessarily want to completely deny the applicant funding. So the Rules Committee is recommending that when extraordinary circumstances are not present, the relevant committee, which in this case would be Eligibility and Budget Review Committee, could grant an extension with conditions. And those conditions might include requesting a corrective action plan to avoid delays in the future, or if the delay is caused by an issue with the auditor, requesting a notice when a new auditor is secured, for example. So for late For late application materials, again, applications, budgets, budget narratives, the committee is recommending that State Bar staff have the discretion, but not obligation, to accept late application materials up to 1 business day after the posting deadline upon written request and explanation for the delay. State Bar staff would, though, report late submissions, even those accepted by staff, to the relevant committee. Any submissions that came after 1 business day or within 1 business day but staff don't accept would go to the relevant committee for review and decision. The committee would then have the authority to accept with conditions, or reject those materials. And if the committee wished to conditionally accept, some conditions might include requiring a corrective action plan, additional monitoring, contacting the organization's governing board if appropriate. And when determining whether to accept a late submission, or what, if any, conditions to put on that acceptance, State Bar staff and the committee should consider these factors: how late the submission was made, the completeness of the submission, reasonableness for the explanation of the delay, any mitigating factors brought forth by the applicant, the number of late submissions made by the applicant in the last 3 years, and any other similar factors they deem relevant. And the Rules Committee is recommending the same framework for both discretionary and non-discretionary grants for consistency's sake. The real difference here would be that if an applicant is denied IOLTA EAF funding, they're entitled to a written notice of that denial and can request a reconsideration by the commission. However, commissions or committees that oversee discretionary grants have the authority to deny funding without that appeal mechanism. Also wanted to flag, committees that oversee discretionary grants will likely be less willing to accept late materials given the competitive nature of those funds. And then transitioning from application materials to reporting materials, the Rules Committee recommends that State Bar staff maintain authority to accept late submissions, again, upon written request and an explanation of the delay. But State Bar staff should report late submissions to the relevant committee. And the reason why we didn't kind of mirror that approval process at the committee level is because there are so many different quarterly reports, annual reports that seemed really onerous on committee members. But upon a report of late submissions, the committee would be able to take action it deems appropriate to evaluate the organization's administrative capacity and compliance with requirements. And those might look like the conditions that would be put on a conditional acceptance of an application. And then finally, a history of late submissions of both application and reporting materials would be a relevant factor in determining and evaluating an organization's administrative capacity. And that would be both when measuring that administrative capacity or administration category in discretionary grants, but then also in just assessing overall compliance with trust fund program requirements, because State Bar rules state that programs must submit timely applications and reports to be in compliance with State Bar rules. So we have a proposed resolution. This looks exactly like the one in the memo, so there's not new content here, but I will stop here for questions and comments, and it looks like Kim has one.
Thank you for all your work and the presentation. My question concerns extraordinary circumstances, which I either missed some language as to what that really means, or you're going to rely on something else. And then the other part of my question relates to, I think it was at slide 9, just no, the list of reasons for why.
Yes, or the list of factors to consider this.
Yes.
Yeah.
So I don't see extraordinary circumstances language there. So that makes me wonder, how does that relate to other language in here? Like an explanation for the delay. Is that the same or different?
Sure, so that's a great question. So the extraordinary circumstances language is in the rules related to the audited and reviewed financial statements only. The working group didn't want to tool with that, but the Eligibility and Budget Review Committee has in the past, I believe, felt difficulty like knowing whether or not something was extraordinary circumstances or not, which is why the working group and rules committee are recommending, so I'm just making sure I get to the right slide, that if there's an extraordinary circumstances, kind of keep what the current process is, they can grant that extension. But if there's not extraordinary circumstances, or it's a little unclear what extraordinary circumstances mean, they can still grant that extension, but with conditions, with gathering some additional information of why this happened, what can be done to avoid it in the future. But then the list of factors here is for application materials, applications, budgets, budget narrative. So it's kind of a different bucket of materials, if you will, separate from the audited and reviewed financial statement.
Right. Okay. Okay. Thank you. That's like a really kind of subtle difference, but I think it's important for us to understand that. And I can't remember because I was on eligibility and budget. I may even have chaired it at one point, but did we not define extraordinary circumstances? We just, it's a little bit like pornography, you know, when you see it.
May I jump in real quick?
Yeah, thank you.
So eligibility and budget didn't define extraordinary circumstances, but they have made a decision of what an extraordinary circumstance could be with respect to a late audit submission a few years ago. It was due to the health issue of the executive director, and it was a very small organization. And so because of that, they accepted the late audit.
Right.
And so that was one instance, an example of what extraordinary circumstances meant.
Okay. So it's pretty much based on what is presented and consideration of whether it's a bit subjective. Okay, I'm fine with not defining it. I just wanted to be clear that I hadn't missed something. Thank you both.
Of course. And Erica, who, as a reminder, was on the working group for this codification issue.
Sorry, a little tricky getting off mute. So Kim, I just wanted to echo kind of what Danielle was saying. Like we hadn't defined extraordinary circumstances. It's just limited to the financial statements and audits. And the reason we tooled with it the way that we did was because we were concerned that it could get swallowed, you know, in situations where we didn't feel like an audit shouldn't be accepted, but maybe extraordinary circumstances weren't met. We still, if we don't accept the audit, then we can't, then there's no application, it's incomplete, and then people could, like the organizations can lose their funding. So that's why we've kind of split these two at this point into the audited financial reviews needs extraordinary circumstances, and the other stuff does not require extraordinary circumstances. We'll just consider the factors listed on the sheet. And hopefully, and as it said, it sounds like you understood that was a subtle difference, and we appreciate that. And I think undoing the extraordinary circumstances rule, we were just a little concerned given that it was, I think, a fairly recently and put together rule.
Right. Okay. Thank you. Makes sense.
Yeah.
Will.
This is such excellent work, Erica, Catherine, Danielle. I really like these improvements. And there was one inconsistency, or at least I felt it was an inconsistency that I was hoping to address with a small amendment to the rules as they've been proposed here. So as it's written, most of our deadlines fall on a Friday, and you get one business day, so you actually get 3 days to submit. And those people who submit on Monday, if they submit it on Friday, they get it in on Monday, staff has the ability to approve those late applications. But if the deadline falls on a Thursday and they get it in on Friday at 6 p.m. or Saturday at midnight or whatever, then it must go to committee. And I feel like that inconsistency, that kind of implied rule, we will give you 3 days except for on those deadlines where it happens to fall on Monday through Thursday, could be addressed by just tacking on another day for non-weekend deadlines that don't abut the weekend. And I raise this for the commission as a whole because this is something that the legal aid community actually asked for. Instead of just one business day, they requested 2 business days. We, in the Rules Committee, we discussed it. It was felt that, well, they get 3 because most deadlines fall on a Friday. But for example, the new grant that we just approved for housing, that deadline is going to fall on a Monday. And that inconsistency gets me. And I think if we amended it such that we said it's 1 business day after the posted deadline, or 2 business days if the posted deadline precedes a business day, then we have a little more consistency in our application of that rule. And so I was hoping to get at least 1 person to sign up for that and then maybe have a wider discussion, but I understand if we can't. Thank you.
Erica, is your comment in response to Will's point? Great. You're on mute still, Erica.
Oh my gosh, I usually try to be good about that. So yes, as Will said, the feedback from the legally community was to have 2 business days, like carte blanche, or not carte blanche, but like for everything. And we didn't feel like 2 days, to Will's point, like if it falls in a weekend and you get 2 business days, you end up getting 4 days versus just 3 days. Just one thing I will say is I appreciate that there was some consideration and discussion about the fact that a lot of our deadlines fall on Fridays. I will also just say, like, at least I can't speak for the whole committee, but for me, that was not actually the entire reason not to do a 2-day turnaround. That I felt like, one of the things that we thought was right now, everything has to come to the committee. There's no grace period at all. We felt like by setting it with 24 hours with staff discretion, it was an opportunity to communicate to organizations that there was a short grace period and that staff had that discretion, but that ultimately the deadline is still the deadline and not 2 days later. And that's why that was my view, at least, on keeping it at 1 day. If however the rest of the commission feels that we can kind of split the baby and do, I guess, 2 days if it's during the week and 1 day if it's on a Friday, like the only thing I'd say is, given the time, I think we ought to just not reword that now. If people are feeling strongly that that's what they'd like to do, perhaps the Rules Committee can rework it. If that's not where people are feeling, then, I think I would like this to go forward. But that's, I just wanted to give some response.
Thank you. And Selena has her hand raised.
Yeah, and I'll keep my comments brief because I know we're at 4 o'clock. I just want to caution against our informal use of grace period, because we don't think of this as a grace period. We think of it as an opportunity for staff to have discretion. And even if we use it informally, I don't think that programs will start disregarding it, because every time there is a late submission, it will still be reported to the commission. It's just really meant for efficiency so that staff can approve these when they're 7 minutes late, an hour late. It felt like every time it came to the full commission discussion about these, small delays, it would be much more efficient for staff to find out why it was delayed. And with the programs that I spoke with, they all seem supportive of, organizations should let staff know if they're having a technology glitch. They should know in advance. And I trust State Bar staff to really follow up with programs, really quickly on, or even day of, to make sure things are coming in. So I think we support this from an efficiency standpoint, and also because State Bar staff do so much work to present this to the commission that could be really used for other work that they're doing.
Great. Thank you, Selena. And Kim's hand is raised.
I think we should keep in mind that this is a proposed rule. There's a 45-day comment period. I would like to make sure that the programs understand this rule is out there, so that they can comment and we consider the feedback very carefully and may require some adjusting. So I would say we should move forward on this. I'm also heartened by Selena's comments. So I think we should move it forward. There'll be a 45-day public comment period. I'm wondering, Selena, if you help alerting the programs to this so that we can get full comment and feedback. And then I think we move from there. It goes back to Rules Committee to consider the comments. Thank you.
I agree, and I will so move that we adopt the resolution as framed, incorporating the rules or the, as they're currently framed, the proposals as they're currently framed.
No more.
Second,
I'll do roll call. Rhinus,
yes.
Savage,
Yes.
Schreiber, Vanarelli, Aglagi. Bonachet, Aglagi. Al-Saraf. Okay. Al-Saraf. Ball. I think Jeff left too. Okay. Fight Master. Bennett,
Yes.
Blakemore, Bushelli,
No.
Connolly,
Yes.
Friedman, Galkin,
Yes.
Fiskin,
Yes.
Judge Klein,
Yes.
Cruz, Lee, Joseph Lee, Mahoney,
Yes.
Meeker,
Yes.
Brady, are you still on? I'm sorry, my brain froze a little bit. I have 9, but it's not quorum, but there was only 1 no, so that's still passed, right?
I think we've asked Brady this question before, and his answer was if we start with a quorum, then the meeting is properly constituted and we can proceed as members drop off with a majority vote.
Okay, so then motion passes. Thank you, Rich.
Great, thank you.
And Rich and Kim, there are 3, so we won't be able to get to my recommendation is that we not pursue the RFP discussion today, discretionary grants, because that's going to take about 20-30 minutes. But if people can stay on for 10 minutes, we can do liaison updates, and then I could do the functional matrix in 5 minutes.
I think that's the way we should proceed. We're losing people, and this is a quite complex issue. So
Okay.
let's move to liaison reports.
Can I do functional matrix? It's just an update.
Sure.
Yes,
Okay.
do that first. And then maybe the liaison reports can be like literally 3 minutes.
So
we're losing it. Whether they're here or not, they're losing it.
Selena already promised.
Okay, thank you.
So the functional matrix, this is actually really timely, given our discussion today. So as you recall at the last commission meeting, in light of the passage of SB 211 that confers additional authority to the Legal Services Trust Fund Commission, the commission asked the Rules Committee whether they can update the functional matrix. And for the new commissioners, the functional matrix was passed about 4 years ago as part of the Appendix I review, which took a kind of deep dive of the commission, its governance authority, its size, its structure. And from that kind of stakeholder working group process, a functional matrix was passed, which outlines the role of the commission, staff, as well as the board of trustees. So the commission decided at the last minute to have the Rules Committee update it to reflect the new authority given to the commission. There was a working group formed for that. And the working group's proposal, and I'll show you the matrix a little bit. It's a bit unwieldy. Erica Connolly's on that working group, and as well as Amin Al-Saraf. The matrix is literally like a chart, and our policies are in there, and it's such an important kind of policy in terms of what is the commission's role, what is staff's role, and we've seen it play out today in many agenda items that the working group is proposing to take that matrix and turn it into a narrative and have it be a more involved process. And at the end of this year, have also the committees work on respective pieces for their committee. And at the end of this year, have a very full kind of discussion. And let me just show you the matrix and you'll see what it's included in your meeting materials, but. So this is here, the matrix, and it's pretty unwieldy in terms of like as a policy document. It outlines kind of the key grant approval administration functions, the current state bar role, the commission role, the proposed staff role, the commission role, and then what the board of trustees is. So we want to take all of this substantively and turn it into a narrative. Also, we would like to send it out for public comment. And it wouldn't be codified in a state bar rule, but perhaps it lives in a commission board book or something of that nature. And we don't need a formal vote, but that's the track that we would like to proceed.
Just for new commissioners and folks who aren't familiar with this is a rules-based system of grant making. The transparency that this provides for our grantees in terms of how we make decisions on grant making drove this, and the new legislation is going to amend it. If you looked at the matrix, much of this is the changes that are recommended today, although we won't be voting on it, reflect the new reality created by SB 211 of the role that is played by the commission versus the state bar. And if you want to get some academic background on it, I recommend a book called Noise by Daniel Kahneman and 2 other authors. Back to you, Dawn.
And that's it. That's all I have, unless there are questions and comments. Great, thank you, everyone. Rich and Kim is just the 2 liaison reports.
All right, over to Selena, I think.
I will keep it very, very brief. The update from LAC is that we are busy in the legislative session doing a lot of advocacy work on bills that impact legal aid. And Lauren is she may be jumping between calls. Lauren is our legislative lead and working on budget work as well. And we've been working very closely with the State Bar staff and the Judicial Council staff on any budget asks that end up potentially coming through this commission. So as we mentioned earlier, there are some potential increases in funding for legal aid, and we hope to have good news for you in the future. And that's my update.
Thank you.
Bonnie, got a wrap for us?
Bonnie, we can't hear you, even though it seems like you're not on mute. No. Okay.
Well, that'll do it.
I think she's saying things are great.
Well, Bonnie, we've lost your audio there, but any help from our side, Dawn? Can we do anything from our side to help?
I don't think so, because it shows her as unmute.
Okay. All right, then let us move to adjournment.
Hey, Rich, this is where Bob Planthold would typically come in
Yes, it is.
during the meeting. And so with good thoughts about Bob in our minds.
Good for you, Eric. Thank you for that. And thank you all for persistence and hanging in there. Bonnie, you can phone it in later. Thank you.
Thanks, everybody,
Thanks for all of your patience.
and your comments and good thinking about everything we discussed. Thank you so much. Stay well.
Yeah, totally.
Thank you all. Have a great
Bye.
weekend.
You all too. Bye-bye.